disciples are scared, but they will all come back to you. Yeah, they will all come back to you. But nobody there means no one to share your last meal with. Your spirit's in disrepair. You wonder if Siddhartha wished all the Buddha. Was he scared? Hope his people make it back to hell. Hope his people make it back to hell. Was Jesus' Father fair? Was justice done there on that limb? God's hand must have been scared, because the devil's always after him. Yeah, the devil's always after him. Oh, Apollo, can we be spared and wait for impending disaster? Oh, does anything care? Oh, they write in Zoroaster. Oh, are you even there? Or is it life in darkness after? Oh, is it life in darkness after? Oh, are you even there? Or is it life in darkness after? Oh, is it life in darkness after? Oh, about the way the world's crumbling. You feel it a bit unfair. There's no one there to look after you. Your disciples are scared, but they will all come back to you. Yeah, they will all come back to you. But nobody there means no one to share your last meal with. Your spirit's in disrepair. You wonder if Siddhartha wished all the Buddha. Was he scared? Hope his people make it back to hell. Hope his people make it back to hell.
have been scared, because the devil's always after him. Yeah, the devil's always after him.
Oh, Apollo, can we be spared? Gonna wait for impending disaster. Oh, does anything care? Oh, they write in sorrow as to. Oh, are you even there? Or is it life in darkness after? Oh, is it life in darkness after? Oh, are you even there? Or is it life in darkness after? Is it life in darkness after? About the way the world's crumbling down and down and down. No beach, just coast will come closer to town. Well, I see San Francisco Bay in the sundown through goggles or underground. Suddenly, California can't be found. Should all take a good last look around. It's closing time. I leave home. The neon glow and the open sign. You're coming anytime, but you passed it by the road you're on. Gotta try to turn around your own design. Oh, but you're running out of time. How long do you think we'll stumble around and drown, saying the structure of the world was faulty found? For what it's worth, the earth is round. Ain't got no good news to say, so say nothing at all, at all, at all. How long till the third tallest tower falls? It's closing time. I leave home. The neon glow and the open sign. You're coming anytime, but you passed it by the road you're on. Gotta try to turn around your own design. Oh, but you're running out of time. There's hope alive inside. You're coming anytime. There's hope Ever since our two roads have crossed, I don't know if I'm lost. I suppose that it's possible. Could you help me find God? I'm exhausted. Had it, I lost it. No matter the cost, won't just watch you walk on by. Could you say it if I should even give it a try? I don't want you to lie. I want your love is all I want for my life. To have love is all I want for my life. To have love is all. To have love is all I want for my life. To have love is all. And I wonder now if you knew somehow I was following behind. I'm on a cloud to help me write down this song of mine. You hold your head down, 'cause it's always on your mind. It's always on your mind. Ever since our two roads have crossed, I don't know if I'm lost. I suppose that it's possible. Could you help me find God? I'm exhausted. Had it, I lost it. No matter the cost, won't just watch you walk on by. Could you say it if I should even give it a try? I don't want you to lie. I want your love is all I want for my life. To have love is all I want for my life. To have love is all. To have love is all I want for my life. To have love is all. You should say anything I can do for you. Should say anything I can do for you. Should say anything I can do for your love. 'Cause for love you're gonna need two roads have crossed. I don't know if I'm lost. I suppose that it's possible. Would you help me find God? I'm exhausted. Had it, I lost it. No matter the cost, we'll just watch you walk on by. Could you say it if I should even give it a try? I don't want you to lie. I want your love is all I want for my life. To have love is all I want for my life. To have love is all. So I want for my life to have love is all. not next to me, but
Alright guys, we're down at the 2-minute mark. Let's fucking go. You're like the sea I'm sinking in, falling 1,000 leagues in love. And if I were to meet my demise, I wouldn't regret nor rise above. And if you were to wear a disguise, baby, your eyes would be enough. See your worth lies far within. I believe I found
a diamond in a rough. And
I wanna do something with this life I'm lucky to live. For this world I'm living in, so I'll never stop loving. Because I am a man made up of more than just the sum of all my parts. And baby, I believe your body's a work of art. So show me an open mind and I will hold you in my arms. So you can feel my heart beat faster for you. Can't you feel my heart beat faster for you? Can't you feel my heart beat so much faster for you? Oh, no, no. Let's fucking go. Let's fucking go.
Than a candidatorial action? Interesting. By interesting, I mean retarded.
The defendant asked
Retarded.
the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as
Let's
their job.
fucking go!
That's an official act.
That's wild. So like this is so he's going with. So I want to hear the assassination question again, because now it feels like we're essentially saying everything can be an official act as a president. Basically, any possible thing you can do could really be an official act. Yeah.
That's an official act.
Well,
All right,
attempting
I'm gonna
to
pee
defend
first.
The integrity of the election. I mean, that's
Hang tight.
The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is.
Oof. Well, to be fair, Obama assassinated an American citizen, didn't he? Yeah, but it was clearly under the purview of his job as president, and to draw like an individual benefit there or something. I mean, unless like you had like evidence that this guy, you know, fucked Michelle or something, I don't know how you could possibly make that comparison in good faith. It's a totally different thing.
It is extremely strong precedent from this court.
Does it strike you as odd that your understanding of immunity goes way beyond what OLC has ever claimed for a former president?
I view the OLC opinions here as strongly supporting us, because any time a congressional statute basically got anywhere near touching the president's prerogatives, they've said, oh, we're going to interpret the statute narrowly to avoid that. So
well, that's a different question. I mean, what OLC has...
Also, let me just do a little bit of progressive circle jerking. How cool is this? It's a monumental Supreme Court decision that's being decided by our highest court. And look, you've got 2 black people, you've got 4 women. Look at the composition of this court. How cool is that? Wow. I'm not going to try to guess ethnicities, but that's a cool thing.
Has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty.
One thing I will say is that if the Supreme Court were to make a broad ruling on this and were to appeal to those original statements, I would be incredibly ass-pained, given how much and how keen they were to completely throw out every historical statement relating to the 13th, 14th Amendment in favor of, like, keeping the country cohesive and together. That would be very funny if they completely 180'd on that. It's like, actually, you know what? Based on these statements in 1812, we think that the president actually enjoys super immunity from every single potential charge. I don't think they'll rule that broadly. That would be wild, but...
That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before...
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act.
But plainly unlawful? I mean, he's the chief executive. He's the commander-in-chief of the armed forces, right? It's a hard one.
If one adopted Justice Alito's test, that would fall outside. Now, if
You're expecting every single individual soldier to apply...
All right, fuck
that
it. I'm
standard
not
and
wasting
be
my
able to
time.
arrive at the correct answer? There's no criminal liability here for the president whatsoever?
adopts, for example, the Fitzgerald test that we advance, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize...
Okay, I hope they ask, because he keeps saying, well, he's got to be impeached and convicted in the Senate first. What if he's already out of office, though? Can you impeach? I don't think we've asked that question yet, right? Can you impeach and convict somebody after they've been after they're out of office? I wonder if that comes up at all.
Well, he's gone. Let's say this president who ordered the military to stage a coup.
Okay, thank you. He's out of office.
He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief.
Yep.
He
His military.
talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers...
But we already got... But what if he's out of office? Ask again. Kagan, don't let him dodge this. Ask him again.
That kind of
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific...
Okay, but ask if he left office already, though. Oh, we were on it, and then we got off it.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have... And that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
The framers did not put an immunity clause into the Constitution.
Correct. Yeah, that you're reading a lot into that, and they've already given historically the idea that presidents, especially the Nixon example, thought that they could be criminally prosecuted. That's a dumb gishgal. Don't want to go back to that argument. I want to hear the one, but if the president is out of office, how do we hold him accountable then for actions that he did in office? I really, really hope that they go back to. That question. Destiny, this attorney seems very capable given what he's arguing. I would hope so. As an attorney you're sending to the Supreme Court better be fucking capable. You're not sending fucking Giuliani out here, right?
They knew how to. There were immunity clauses in some state constitutions.
Yep.
They knew
Back
how
to
to give
this.
legislative immunity.
Yep.
They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law.
Yep.
Wasn't the whole point that the president was not
ordinary
a monarch,
citizen.
and the
Yep.
president was not supposed to be above the law?
Correct.
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that
Did it? Was it? Broad immunity? From where? I think you have to cite or source something where that was understood to also confer broad immunity from criminal prosecution. I think you have to point to something there, because I feel like the examples that were pointed out earlier by, I don't remember if it was Jackson or who else pointed out earlier, it seemed like nobody's operating under this assumption, especially with the Ford-Nixon thing.
set forth in the very broad language of Marbury against Madison. And also, they did discuss and consider.
I'm also curious, in Marbury v. Madison, I don't even know the details of that case. I don't know anything about it other than that's where judicial review came from. Did this? I don't know enough about what this said or would have said about immunity or implied immunity or any. I don't know enough. I don't know any of the details of that case. I'm confused by this argument. Let's say that Trump actually perpetrated one of the school shootings that happened while he was in office, but the evidence of that was only discovered after he left office. Does his argument mean he can't be charged because it wasn't impeached? Yeah, that's what I'm curious about. That's what I hope that they go back to, because Kagan started asking about that, but then he switched topics here.
What would be the checks on the presidency? And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not.
Well, hold on. Criminal prosecution isn't supposed to be a check on the presidency. It's supposed to be a way to hold a citizen account for a criminal act. It's not supposed. Nobody here is talking about this serving as a check on the presidency.
And consider what would be the checks on the presidency. And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the second volume of Farrant.
Thank you.
Why'd you say thank you? Ask him more. We're not talking about impeachment. Whether you can impeach somebody. It's the question of like the criminal liability here, right? Impeaching somebody and convicting in the Senate that's not a criminal proceeding. There are no criminal convictions for that.
Justice Gorsuch? Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted
Really?
for bribery, presumably after he leaves office.
Congress has a statute. What is that? Congress statute, or what would be congressional statute, president, wait, statute, president, bribery, convicted. He's not just talking about the impeachment thing, right? Or is he? Maybe he'll get more. We'll just let him talk.
Outside the core areas that Justice Kavanaugh was talking about, when Congress speaks clearly, couldn't a statute like that, Congress provide a statute like that would allow all manner of evidence to come in to prove the case?
I think our position is that would have to be an unofficial act, purely private conduct for that prosecution to go forward.
All right, but
For an impeachment
outside the
lawsuit.
core areas of executive power, if there is a clear statement from Congress that something is unlawful and it applies to the president, I'm struggling to see why in that case, perhaps, the evidence could come in.
Yeah, the strongest possible case, in our view, is what you've described as kind of the core executive powers, the unrestrictable powers within the meaning of SELA law. But again, the holding of, for example, Brewster and Johnson that we've relied on doesn't turn on how central it is of a legislative act. It just says if it's an official act, which here we would say applies basically the outer perimeter test of Fitzgerald against Nixon, that doesn't come in.
Lefties are trying to rewrite history to say the Soviets defeated the Nazis, not the U.S. Most Nazis died in Eastern Front. How U.S. defeat the Nazis more? Just because of where you die doesn't necessarily determine who's winning the war or who's doing the most. The only reason the Soviets were even able to fight so much on the Eastern Front is because of all the supplies that were being given to them from the United States. Like the Soviets wouldn't have been able to keep up their war machine whatsoever. They were already like fucking razing every fucking village and city and everything they were leaving behind. They already lost like tens of millions of fucking soldiers like fighting. If it weren't for Lend-Lease, the Soviets would have collapsed anyway. And then that doesn't even count like contributions that British intelligence was making to the war effort, or the fact that there was a whole Western Front being fought as well. Like, fuck off. Fuck Russia. Fuck the Soviets, okay?
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
What is the I'm so curious what I wish they would say. Can you give an example of some of that bold and fearless action that you think might be curtailed in the future? Because what Trump has done here is not bold or fearless. None of the parts of these federal indictments are bold and fearless action by Trump in service of his job as the president and working on behalf of the American people. They're things in service to himself. They're things to personally entrench him into the powers of the presidency. I'm so curious. I doubt I'll ask. I'm curious what an example of some of these would be.
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
I'm sorry, if the court is asking whether they could be...
If the President gives an unlawful order, call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Gouverneur Morris said explicitly at the Constitutional Convention, that his coadjutors could be prosecuted. There is an important caveat because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes. The criminal law books are replete. But, I mean, do you agree, is that one check that's available?
Absolutely. And again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the Recommendations Clause, and therefore we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutors, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.
Justice Kavanaugh?
Just follow up on the OLC opinions question. As you read them, and I think I read them, they articulate a clear statement rule as to this court's cases for covering official acts. And your point, I think, but I just want to underscore this, is that none of the statutes alleged here or cited here have a clear statement covering the president, therefore meaning that the president can't be charged for any official acts under these statutes.
That's absolutely correct. They're extended way beyond. I mean,
Now, that's separate from the question what's official versus what's personal, but for that bucket that is official, there's no clear statement, period.
That's right. And as to purely private conduct, we don't think a clear statement rule would be invoked. But as to official acts, these statutes, the ones charged in the indictment, are just way far afield from purporting to criminalize in clear terms the president's official acts.
And then, just to clarify this, the president's not above the law, the president's not a king. The founders thought that. I think your point in response to that is the president is subject to prosecution for all personal acts, just like every other American for personal acts. The question is acts taken in official capacity.
That's correct. And even those, of course,
Titties.
emphasize the whole series of structural checks in addition to that.
So much titties. Titties for days.
So we're going to ask him if he's already out of office. please let this come up again. Who's listened to this? Does that come up
What's
again?
up, cutie?
On the
You got
source of
titties
immunity,
too.
it's
Let's
not
rub our
explicit in the
titties
Constitution,
together,
also,
even though you might stab me in my
executive
titties
privilege
with
is
your
not explicit in the Constitution,
titties.
Yet in United States versus Nixon, the court unanimously said that the Article 2 executive power in the Constitution encompassed executive privilege, and the same principle presumably would apply to executive immunity being encompassed within that executive power as historically understood.
That's absolutely correct, and there's a very telling passage in Free Enterprise Fund where this court talked about how there's a letter from James Madison to Thomas Jefferson at the time of the founding where Madison said, hey, as for removal power, they did not expressly take this away, so the 1789 Congress understood that it was
Eve,
what
you're a
they
little
fixed. So if the
bitch.
original understanding of the executive vesting clause is broad enough to encompass that, it would have to be expressly taken away, which is the opposite of the presumption that they're advancing here.
And then lastly, I think you've acknowledged in response to others' questions that some of the acts in the indictment are private, and your view is that some are official. Is it your position then that that analysis of which is which should be undertaken in the first instance by the D.C. Circuit or the district court?
Most likely the district court under the logic of Anderson.
Thank you.
Justice Barrett?
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase.
Plain reading, interesting. So he's okay. So I don't know if this has been tested before, but some people, I guess, are reading this. So Article 1, Section 3. Let's get this. Oh no, this is wait. Article 1, Section 3, Constitution.
Dick. Oh, we got some
Clauses
dickums
6
up in
and
this
7.
one, boys.
The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So this is just saying that if the House is impeached, it goes to the Senate. The Chief Justice of the Supreme Court sits as the presiding over the court, basically, and then 2/3 of vote will vote to either convict or acquit. And then for Clause 7 here, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So this means that the maximum penalty for a conviction in the Senate of the impeachment means that they just are kicked out of office and can't hold any future office. That's the maximum penalty. But then it says, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So he's saying that the plain reading of this, now I don't know what the agreement is on this, he's saying that the plain reading of this is that, well, if you want to indict, trial, judge, and punish a person, like the president, it can only happen after a conviction in the Senate of a House impeachment. I don't know if there's like a broad agreement on that. I wouldn't agree that that's a plain reading, that that's the only way. I don't think that's a plain reading at all, because it seems like you're relying on the implied stuff from the vestment of the executive powers or whatever, and then you're saying, well, look, the only way you can do it is explicitly written here. But that's the argument that he's rolling with here. I don't know if there are I don't know what constitutional lawyers say about that. I'm not sure.
Titty,
Okay,
titty,
so there are many other
titties.
people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment.
Okay. So she's giving, good job. Yes. Amy also, a huge sub, tier 5 sub in chat. We talk a lot. So Amy's saying that, like, you can criminally charge anybody. Nobody's suggesting that impeachment is the gateway, as she says, to criminal indictment. You can be criminally indicted without being impeached, is what she's arguing.
Suggested that
Fuck it.
impeachment would have to be
Here
the
we go.
gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials. He said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president.
Interesting. So only the president has this particular power applied. It's a unique power only to the president of the United States. Anybody else could be criminally charged, not the president, though.
Mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional
What if the
structure.
criminal conduct isn't discovered until after the president is out of office?
Yes, please don't let him wiggle from this. I really, really, really want to hear an answer to this. What if it only happens after he's out of office? Hold on. Please, I just want to hear the answer to this. Don't let him squirm. I need a sippy soy.
Try entering the code. It worked. It's because of the city's unstable terrain. You'll get used to
So there was no opportunity for impeachment.
We say the framers assumed the risk that of under-enforcement by adopting these very structural checks as
No shot. Did he just say shit out of luck? That can't possibly be the argument. I'm slowing this down. No shot. That would be wild.
this novel context where it clashes with the constitutional
What if the
structure.
criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assumed the risk that of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Oh my God. That's a wild statement. Train says you're manipulating XQC against Aiden. You can link me a timestamp. I'll go over it later, but...
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That
Oh, wait, what? So the president can only be criminally charged with what the impeachment proceedings in the House and the conviction of the Senate specifically dealt with? Those are the only criminal charges while acting as president?
the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after...
Wait, is that plainly in the law? The Senate shall I'm just want to read this one more time. I'm sorry. Because he's reading a lot into these two clauses. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. And then again, rereading this clause, judgment in cases of impeachment shall not extend further than to removal from office and the disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted, oh, it does say convicted, and it says judgment in here, which also applies. Okay, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I wonder where he's getting the, I guess he's reading into it because it's not plainly stated here. Well, arguably this is not plainly stated. It must be convicted in the Senate in order to face any criminal charges. But now he's saying that the criminal charges that you face after conviction in the Senate can only be about what you were impeached and convicted in the Senate for.
don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. Isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's...
Nevertheless, in spite of that, notwithstanding, all the same, that is what nevertheless means. Is that really the reading of this? Does every constitutional scholar agree on this, or is this contested or debated? I don't think it's a plain reading at all of this. That the only way that, because what he's saying is that this clause is saying the only way to criminally charge a president is to impeach them first, and then for them to be indicted in the Senate. And his plain reading of that comes from this. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I don't agree with that in plain reading at all. I think it says I would almost argue it says the opposite, or it's ensuring you that you also still have the right to take them to trial. I almost feel like this is a protection from double jeopardy, basically, or like saying that like it's not double jeopardy if you take them to criminal court after the impeachment. That's almost what this feels like, more than.
Everybody look away! Look away! Look
More than a
away!
clause that says it's the only way to criminally indict a president, unless there's other constitutional lawyers or scholars that read this differently for other reasons. But yeah, I don't get that. I don't get that as a plain reading at all. But none of them have challenged him on that reading so far. It doesn't seem so. But maybe it'll come out.
Example of a president who orders a coup. Let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction and an impeachment proceeding.
You are bending over backwards for your interpretation. I don't know how you get there. What are you talking about? My interpretation is the plain reading of the English language here. What part of this implies that that you can only indict somebody after an impeachment proceeding? There is no plain reading of that gets you here. You're implying stuff. A plain reading means that the language set forth as is describes what it is you're saying. If you have to bring in other parts in order to flesh out what this means, then it's no longer just a plain reading. Now you're getting into interpretive stances, I think. LOL, love it when Destiny thinks he's smarter than a judge. Hardcore Cetra, I'm sorry. What have I said so far that's contradicted anything that any of these judges have said? Pretty sure like 95% of what I've said they've brought up eventually. What are you talking about?
If there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of...
Wait, did we get away from the after he's out of office? How do we keep escaping this? I want this answered. Why do we keep getting away from this?
difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
No one will want to be president again if you can be criminally prosecuted for any little thing by the other party. Well, no, I'm sorry. You can't be criminally prosecuted in the United States for any little thing. You can be criminally prosecuted for criminal acts, which, as far as I understand, is a good thing. You should be criminal acts should be criminally prosecuted, ability to be prosecuted. That's a good thing.
Immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be
Right,
made.
but I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to...
Oh, no, wait, you're right. He did answer it. He said you're shit out of luck. If the president gets out of office, then just nothing happens. God, that's such a wild argument. So if you're a president, like, just commit crimes, I guess, like, in your last week or two in office?
Have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that.
Isn't what Biden's doing at the southern border a crime? individually? What private act has Biden taken at the southern border? What could you even begin to call a private act there? Unless you've got video footage or accusations of him, like, sneaking around trying to let people in personally. What the fuck are you talking about?
Capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
The law, yeah.
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts, but the remedy for that is the question.
Impeachment.
Could he be subject to personal vulnerability, sent to prison for making a bad decision?
This is so boring. Is the rest of this going to be any different, or are we going to loop on these same stupid fucking points? I wonder. We'll see.
After he leaves office.
But other people who have consequential jobs and who are required to follow the law make those determinations
all the time
against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to
Easy
be able
peasy.
to act boldly, do, you know, make
Oh, that's true. We're going to get the state side of this soon, which will be interesting.
kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of
Badass.
decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. So
I say two things in response to that,
Yes.
both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
no, but
Do they read super chats in the middle or at the end of this stream?
let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high-profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, you know, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He is required to follow the law. And what
But he's
Fitzgerald
not
said is
if
that
there's no criminal if there's no threat of criminal prosecution. What prevents the president from just doing whatever he wants?
all
yeah.
the structural checks that are identified.
But you said it yourself, there's no structural check at the end of his term. In the last month, he's basically free to assassinate whoever, rape whoever, personally murder, beat the shit out of whoever. Like, he can do whatever the fuck he wants because he can't be held to account unless he's impeached first. So if it's like the last day or two, it's basically like the fucking purge. It would make, I would say, for a very fucking funny movie where you live in a world where, like, the last day the president's in office, it's like a zombie movie or some shit, or like, you have to just avoid the president at all costs because you know that whatever he does, he can't be held to account for. It's like fucking, I don't know, Groundhog Day, or some weird shit, but just for the president on the last day of office. Like, the White House empties out, everybody's, like, running for their fucking lives.
In Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled.
Yes.
If someone with
Yeah, now she's giving the other side, because I've given this a few times. Like, the extreme side is like, oh no, a president can be sued for anything. They're not going to take any brave actions as president. That's not good. But what about the other side, where a president can commit unlimited criminal acts, but he says that they're all in the official capacity as president? Well, isn't that, like, equally or possibly even more terrifying? Rather than a president over-encumbered by criminal law, but instead a president completely unrestricted by criminal law?
An opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there
no
would
criminal
be
liability,
no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
He's just going to say, well, there's a structure for that, and that structure is impeachment. He's going to repeat that again.
I don't think there's any allegation of that in this case. And what George Washington said is What Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional.
He's just repeating the same shit he said before. It's not even.
And what George Washington said is,
Wait, I'm curious. What is the source of that Benjamin Franklin quote? Does anybody have that? I'm curious what he's referring to there. Benjamin Franklin quote. Criminal prosecution president. I'm so curious what he. I'm so curious. He keeps referring to a particular moment in debate. I wish I knew what it was. I don't know what he's referring to.
we're worried about factional strife, which will
No, let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say, no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years.
There's a disagreement. There's a factual disagreement on that they don't ever seem interested in resolving.
There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question. Let me ask you another question about this clear statement line of questioning. First of all, I didn't see you argue that below. I don't know. I understand that you have that set of in your briefs here, but did you argue before the D.C. Circuit something about a clear statement with respect to statutes?
Yes, in our separately filed motion to dismiss based on statutory grounds, we extensively argued not just this clear statement rule, but a whole panel.
Right, but that's not the question presented in this case. The question presented in this case comes out of your motion for immunity. So to bring in now an argument that you didn't raise below, it seems to me you forfeited it, no?
I believe it's fairly included within the question presented,
Why?
Especially because the court expanded the question presented from what either of the parties submitted.
But not to statutory interpretation. I mean, that argument goes to statutory avoidance, constitutional avoidance, statutory interpretation. You asked for immunity, which is a totally different thing.
I think they're very closely related logically. The question is does immunity exist and to what extent does it? And the argument is, immunity at least exists to the extent that it raises a grave constitutional question, and that triggers the clear statement rule. That's a really
But
tight
that's
logical
totally
relationship.
circular. You use that argument to avoid constitutional questions. You are asking us a constitutional question here, so it doesn't even make sense to talk about clear statement in rule the way that it's come up in the context of an immunity question. But let me ask you this about it. I have one more question. So what is the argument that the President of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law? I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress, in every criminal statute, would have to say, and the president is included. I thought that was the sort of background understanding, that if they're enacting a generally applicable criminal statute, it applies to the president just like everyone else. So what is the clear statement that would have to be made in this context?
Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers, and we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
The heartland of core executive authority is creating a false slate of electors to try to overturn and to lie about elections. That's a core duty of the president. That's funny.
Thank you.
Thank you, counsel.
Not even arguing that that's like a peripheral duty when we should just be safe and err on the side of caution, but that's a core duty of the role of the president. Okay. I think next is the arguments from the state now for this case. The argument saying that Trump shouldn't have immunity. The counter questions will be interesting. I'm going to use the restroom real quick. One sec.
So a little easy.
Okay.
Mr. Dreeben?
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official.
Okay, this is going to be the state's argument now. Assuming this lawyer isn't retarded, he has to know that he's arguing for the end of a democratically accountable executive branch. Is it safe to assume that this lawyer is basically a fascist? He is not ignorant enough to just be a useful idiot. I don't think that what's being asked for is so clearly over the line that I would ascribe like malintent or bad faith to the lawyer here. No. Especially when it comes to matters of like constitutional questions and procedural things. I think it's good to fight about a lot of these things in a very aggressive manner. And a lawyer should be the strongest advocate for a particular position. I think there's nothing wrong with that. Yeah, I think that's totally fine. And if there is an issue here, then it's one that, you know, we should patch. We have a constitution that we can make amendments towards. We've got a Congress that can pass laws. Like, there are other things that we can do. Yeah.
Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former
Wait. History furnishes one example only of a first magistrate being... Friday, July 20th, 1787. Madison debates. What are these debates in Congress, or are these just like debates that are happening on Benjamin Franklin's YouTube channel, or? Franklin was for retaining the clause. Point. Okay, hold on. What are you even talking about? If he be not impeachable whilst in office. Okay. If he be not impeachable whilst in office, he will spare no efforts or means whatever to get himself reelected. He considered this as an essential security for the good behavior of the executive. Mr. Wilson concurred in the necessity of making the executive impeachable whilst in office. Okay. All right. He can do no criminal act without coadjutors who may be punished. In case he should be re-elected, that will be sufficient proof of his innocence. Interesting. Besides, who is to impeach? Is the impeachment to suspend his functions? If it is not, the mischief will go on. If it is, the impeachment will be nearly equivalent to a displacement and will render the executive dependent on those who are to impeach. So this is saying that essentially the president will be held hostage by Congress. Okay. No point is of more importance than the right of impeachment should be continued. Shall any man be above justice? Above all shall that man be above it, who can commit the most extensive injustice. When great crimes were committed, he was for punishing the principal as well as the coadjutors. There had been much debate and difficulty as to the mode of choosing the executive. He approved of that which had been adopted at first, namely referring the appointment to the national legislature, One objection against electors was the danger of their being corrupted by the candidates, and this furnished a peculiar reason in favor of impeachment whilst in office. Shall the man who has practiced corruption and by that means procured his appointment in the first instance be suffered to escape punishment by repeating his guilt? So this is saying that, like, okay, well, if he did something illegal to become, to be in office, now is he basically able to continue to do that illegal thing, and now he can't be held accountable in office? They're arguing for impeachments in office, I guess. And then Franklin was for retaining the clause as favorable to the executive. History furnishes one example only of a first magistrate being formally brought to public justice. Everybody cried out against this as unconstitutional. What was the practice before this in cases where the chief magistrate rendered himself obnoxious? Why recourse was had to assassination, in which he was not only deprived of his life, but of the opportunity of vindicating his character. It would be the best way, therefore, to provide in the Constitution for the regular punishment of the executive where his misconduct should deserve it, and for his honorable acquittal when he should be unjustly accused. Okay. Warning, I don't have the full background for what this conversation is, so everything I say could be wrong, but it sounds like here, what they're arguing for is, should you be able to impeach a sitting officer of Congress or the president, if you think the president's not an officer of Congress, and they're arguing whether you should or shouldn't be able to, and it sounds like Franklin's argument here about a magistrate being formally brought to public justice has to do with, like, and the fact that you could assassinate somebody if you don't like them. He's saying, well, of course we should be able to impeach somebody. Like, we need a way to remove somebody from office if we don't like the job they're doing. We need a way to remove them from office. I don't think he's necessarily saying here that, like, criminal charges are bad. I think he's just arguing for an additional layer of protection, which is impeachment from office. That's how I read this, but I could be misunderstanding the context, maybe? I don't read this at all, though, because the last lawyer, Sauer, brought this up like 50 times. It seems like he was bringing up this quote. This doesn't sound like it has anything to do with whether or not you should be able to criminally convict a sitting officer of the court or an elected official. It sounds like it's just saying that, like, we should be able to impeach somebody so we don't have to criminally convict them, or so we don't have to assassinate them. But I don't know, yeah. So it seems silly. This quote doesn't seem very relevant, but I mean, none of them brought it up. So either they're unfamiliar with it, they didn't care about it, or they disagree with my interpretation, so who knows. Okay, the state's argument, back to this, sorry.
Presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises...
Sorry, yes, what Caleb said in YouTube should I agree with. Dustin, I think you're right. He's saying in office, there should be a different, more peaceful process that doesn't punish the official like we would a criminal. Yeah, that's what it sounded like he was saying, right? Like, how do we remove somebody from office? Like, we've got to convict them of a crime, like in criminal court, or we have to assassinate them? Why don't we have a process to remove somebody, like impeachment, that doesn't involve a criminal procedure? But it doesn't sound like that quote is in favor of precluding a criminal procedure. It sounded like that quote was in furtherance of the idea that we should be able to remove people from office without necessarily having to do criminal procedures. But our question for Donald Trump here isn't about removing him from office. It's about crimes committed while in office, right? It's a fundamentally different question, is what it feels like to me, but...
Concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today.
Does impeachment actually accomplish anything? Well, it helps you remove somebody from office. That's the point of an impeachment, right?
This court should preserve it. I welcome the court's questions.
I do agree there as well. I'm shocked it's being argued if the president has immunity from the law as if he's a monarch. That does feel like an incredibly un-American idea, that we're having a serious argument before our highest court for whether or not our president, who is very much not supposed to be a king, has full immunity while in office from criminal prosecution. Now, the counter argument to that is going to be, well, hold on, but a king can't be impeached by his court, whereas the president can be, so it's fundamentally different. But still, it's a little funny.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert, as applied, Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions.
Wasn't Trump impeached twice? Am I retarded? Correct. Impeachment is when the House, the House of Representatives is the only thing in the United States that has the power of impeachment. I think, at least for the president and for people in the House, I think. The House does impeachment. Once the House votes in favor of or against impeachment, then it goes to the Senate, and then the Senate votes to either convict or acquit. Technically, the process in the Senate is not called impeachment, but people will say that.
Yeah, so earlier on,
oh, yeah, did the Senate vote for
see,
impeachment or not?
he's
Technically,
ignoring the
the Senate doesn't actually
fact
vote for impeachment. The Senate votes to either acquit or convict. If you want to compare it to like a criminal
that
matter,
earlier he said that he
court's
didn't
work,
get
think of
impeached
the
twice
House
while in
is almost like a
office.
grand jury,
He
maybe,
did
where
get
the House
impeached
sends
twice while he was in
the
office.
impeachment to the
He
Senate,
didn't get
and then the
convicted
Senate would
either
vote
time,
on whether or not
and
to
his second
convict him of the
conviction
charges
was
or acquit the
held
accused
after
of
he
the
was
charges,
out of
the
office.
charges of- and then if they convict, then they're convicted of, I guess, impeachment. But technically the impeachment thing is a process that is only happening in the House. Yeah.
That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Do you know what the special counsel's role is in this case? I don't think the special counsel is directly involved in this case, but there's a fuck ton of crossover from that case, right? When you say special counsel, you're talking about Jack Smith, right? This case has to do... Now, this guy's... Michael Dreeben is counselor to the special counsel. Is he arguing this case? Or... Because this case is a... This is the case... This is about a civil case for part of the Capitol Police suing Trump for civil liability relating to the riots, basically. But there's going to be a lot of questions answered here that have to do with the Jack Smith case. I don't know if this guy is relation to Jack Smith at all. This is the special counsel lawyer that they brought to argue this. Okay, but is he related at all to the Jack Smith stuff? Like, does he have an official position relating to that? Or is this just the special counsel from... I don't even know who does this come from. This is Jack Smith's team. Okay. Yes, okay. Is impeachment only for removal if convicted, or is that to actually charge the president of a crime to serve time? No, nothing about impeachment in the Senate or the House has to do with a president serving time. It's only to remove somebody from office and make it so they can't serve in office further. That's the only thing a conviction in the Senate can accomplish. Can somebody please correct Destiny? This case is not in relation to the civil case. This is an appeal from the federal judge Chutkin case. Wait, my understanding... Wait, is this not from the... Hold on, let me read exactly what this... Because they kept... Or, I'm sorry, because they kept referring to the... Fuck, what was the name of that? The gaming... Oh my fucking god, I don't remember the... They kept referring to the... Blazin' game case. Is this not the one that is... Oh, maybe this isn't the case. Maybe they're just referring to these other cases. Hold on. Supreme Court oral arguments. You're mixing up Blazin' Game. Yeah, I am. Hold on. What is this? Is this in relation to? Wait, so what is the case that this is in relationship to? In relation to? Like, does anybody know the name of the case? Why is this shit so hard to fucking look up? Show me clear. Somebody needs to make a wiki website or a fucking website for the federal government or the Supreme Court. Notice hearing arguments in Donald Trump's broad presidential immunity claim. The arguments focus on Trump's criminal charges over his attempts to overturn 2020 election results and whether they should be dismissed based on that broad claim of immunity. This sounds like then it is over specifically the Jack Smith, which would make sense. It would make more sense than what I was saying before. The Jack Smith federal indictment. Is that what this is over? Or... It's Trump v. United States? Okay. Then the indictment that we were looking at earlier is the one that this is over. This case would be my guess, right? So this is actually specifically, but I don't know the structure of how you get like one part of an argument to the Supreme Court, because the Supreme Court isn't going to determine the total outcome of this case, right? The Supreme Court is just determining a particular argument about the criminal immunity thing, right? I believe the federal judge in the Jack Smith case deferred it to the Supreme Court to rule on presidential immunity. Okay, interesting. Okay, I don't know the structure of how you can refer part of a case or a procedural question just to the case, but.
That ass, though.
Trump v. United States.
Down bad, yes I know.
Whether and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Pretty much whether the case can be brought to trial or not. Interesting. Okay. Okay.
To assure that the president can perform all of the important tasks that the Constitution reposes in him.
In not so distant past, the presidents, or certain presidents, have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts.
Okay, this is going to be an important one, and I hope they dive into this a lot. People will say things like, oh, well, we should convict him. Obama did a crime. What was the crime? What was the crime committed? What criminal statute are you even referring to here? Like conspiracy to commit murder using the it's hard to it's hard to even imagine like what are the crimes that we're talking about. But I imagine we're at the end of this. Big fan, Destiny. Just wish you weren't violently racist sometimes. Part of being white. What are you gonna do?
At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing.
Yes, so if you're DOJ, the body that would prosecute
Dope.
you, it seems very strange to think that, imagine a prosecutor telling you, hey, you can probably do this, it's legal, and then you do it, and the prosecutor says, hey, I'm going to charge you with a crime. Wait, what? Makes sense that if you're working on the advice of your Department of Justice, which most presidents should be in terms of what's legal or not legal, then the idea that you would be charged with a crime is self-defeating. You don't have to even worry about this question because it just wouldn't come up. But in the case of Donald Trump, remember, William Barr? Wait, it's Barr, right? Yes. Is not telling Donald Trump that any of this is legal. No, he's not getting advice from any good U.S. DOJ counsel telling him that any of these actions are legal or good. That is not the case. So,
itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would
Wait, they've referenced OLC a lot. Can somebody tell me what OLC is? Some other case or some other... What are they referring to over and over again when they say OLC? The Office of Legal Counsel. Is that who they're talking about? Okay. I should have looked this up before. Okay.
which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement? Said,
after a terrorist, for example.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but...
Yeah, of course you're charging somebody if you violated a law because they violated a law, right?
I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Yep.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law.
He's being prosecuted because he's broken a law, right? Robert sounds like he's looking for a positive argument that the president can be prosecuted, but I think that the state, Dreeben, is arguing that it's just an assumed thing that he can be prosecuted. I don't need something that says, like, when I say positive, there's like an explicit statement that he can be prosecuted, but it seems like the other argument is going to be, well, you need to show me something that says he can't be prosecuted. Why would we assume an American can't be prosecuted? The default assumption is you can be, not that you can't be.
The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said, but there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in some cases. I'm not suggesting here.
What a retarded fucking statement.
So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are
My
not
friend,
endorsing a regime
you
that
need
we
to
think
ameliorate
exposes
your
former presidents to
loquaciousness.
criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So I don't want to overstate Your Honor's concern with potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement. Because the fact of prosecution was enough to take away any official immunity, the fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution.
Yeah, this is, I don't understand. Roberts seems like he's arguing from a position, a starting position, that immunity is there, and that, so earlier when Roberts said that it was circular, Roberts is saying, how can you charge a guy who's the president with a crime? And Dreeben is saying, well, I mean, if they're charged with a crime, you can charge them with a crime. And Roberts is saying, that's circular. What do you mean? That doesn't make any sense. But what Roberts is really asking isn't, how can you charge someone with a crime? Because that would obviously be tautologically true. You can charge them with a crime if you charge them with a crime. Roberts is saying, what part of charging him with a crime removes the immunity? It sounds like you're saying that you can charge a president with a crime simply because you think he's committed a crime, but he's starting with the assumption that there is immunity there. How do you remove the immunity? When I think that's kind of the central question of the case is there immunity there? I don't think we're starting with an assumption of broad immunity and then finding out how we can get around it. I think we're starting with the assumption that the immunity is what's at stake here, which I think is Dreeben is about to argue that, well, we're not, where does that immunity even come from? It doesn't exist.
Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today.
Yeah,
there
correct.
certainly is no textual immunity.
Correct.
We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution.
Yes.
This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding.
Yes, how he's describing it sounds
I
more
went,
like
got a
reading
war,
between,
and
that
tried to
earlier
fucking
clause.
activate
And
my
it sounds more
fucking
closely aligned with
Spartan
the
rage.
textual reading of the Constitution, that after an impeachment, nevertheless, you could still convict somebody, or you can charge and convict somebody with a crime, but these are totally separate procedures. And also, the more I think about it, the more this makes sense too. It's really good and powerful and positive and amazing that in the United States of America, we have the ability to remove somebody from office with impeachment without requiring a criminal conviction. That's good. It gives us the power to kick people out of office that we feel like they aren't doing their job well without either fabricating or appealing to some sort of purported criminal act. That's a really good structural healthy barrier that we can kick somebody out of office without saying you've committed a crime first, or assassinating them to do that, right? Yeah, this makes more sense, I think, yeah.
The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation.
Yes,
he could be removed.
that wasn't criminal
He can't
conduct.
be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently.
Real quick, whenever they say a statute, are they always talking about the criminal code? Is that the same word that we're using? And when they say statutes, they're talking about the legal code, federal legal code in the United States, right? Or is that more broad or more narrow than that? Yes, the U.S. code. Okay, just making sure. Okay.
Under some statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel in the Department of Justice.
All right, so this is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine, I'm not bound by OLC, and I interpret it differently, so let's go to trial.
Man, something I wish they would do more often. They kind of did in the past. Maybe they'll do it in this year. I shouldn't say this. Or I shouldn't say I wish they do this, because they did do it. Hopefully they'll continue to do it. I wish they continue to use more examples. I hope they continue to use more examples, because I want to hear them talk through particular statutes or particular conduct and see how we would apply the arguments being used, either through those particular statutes or to the particular conduct. I want to hear that.
And then there has to be a trial, and that may involve great expense, and it may take up a lot of time. And during the trial, the former president may be unable to engage in other activities that the
Smith asked the Supreme Court to rule on immunity 6 months ago, and they refused, but it slowly worked up the courts to them, but totally expedited the 14th Amendment case. Sham Supreme Court is helping Trump delay every step. It's obvious. Okay.
former president would want to engage in. And
if I had to guess, my guess is probably just going to be that the Supreme Court really doesn't want to touch this question. That's just that's a feeling, intuition guess that I have, is that the Supreme Court doesn't want to be anywhere near this question, because this is an insane fucking question that the Supreme Court is being asked to address. Which is why I agree, even before listening, with what Esports Batman said, that they're just going to try to kick it back to the lower court, because oof.
May be unable to engage in other activities that the former president would want to engage in, and then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve.
Yep.
In a case where the misconduct occurs close to the end of a president's term,
yes,
Congress is unlikely to crank up the machinery to do it. And
yes,
if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against the most far-reaching aspects of Mr. Sauer's argument, right?
That is correct. And let me turn then to why.
Well, what about, to unpack it a little more, do you agree?
Is this Gorsuch? Who's talking?
That there's some
That's
aspects
Kavanaugh.
of
You don't remember
Kavanaugh
the I like
that
beer
are
guy?
exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay.
Me and
other official
Squee.
acts the president may take that are not within that exclusive
Me and my
power,
buddy Squeef.
assume, for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn, because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article II functions.
Well, you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board that a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371, conspiracy to defraud the United
Oh,
States.
he
can be
just
used
accused
against
you
a
of
lot
vague posting,
presidential
bro.
activities historically with a creative prosecutor who wants to go after a president.
His argument is, or I shouldn't say argument, I'm sorry. Kavanaugh's question here is pointing to the idea that some people don't like the use of 18 USC, I think, any of these actually, to all three of these. 18 USC 371, 1512, and 241, conspiracy against rights, the obstruction of the proceeding, and then the conspiracy to defraud the United States, is because they're saying that the way that Jack Smith is applying these so broadly, using these statutes in a kind of a novel way to apply here to the presidential conduct, that theoretically you could argue that, let's say that Joe Biden decides that he wants to make it so you don't need voter ID to vote in an election. Well, let's say that we make the argument, or a study comes out, or somebody realizes, like, wow, a whole bunch of illegal immigrants just voted. Well, now we're going to charge you under 18 USC 371 and 18 USC 241 that you're trying to defraud the United States citizens, the United States, of their rights, because you're allowing illegals to vote, and you're basically undermining their ability to vote. So you're defrauding us, and you're conspiring against our rights to do so, right? That you might have done that under bad faith. The defraud thing is you didn't actually think that illegals needed to come in. You just did it to win an election, and then it's conspiracy against our rights to have our voice heard in a vote or whatever. It is what Kavanaugh's arguing about, the broadness or the novel, I guess, application of these criminal statutes, which is a valid concern or a valid argument, basically. Yeah.
And 371, conspiracy to defraud the United States, can be used against a lot of presidential activities historically with a creative prosecutor who wants to go after a president.
Well, let me try to backtrack a little bit.
That's what we're talking about historically, is the risk, that, and going forward, the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president. Justice Gorsuch, Section 201 does not specifically name the president.
Well, I assume that's personal, so
well, I think that
that's what Brewster said.
Bribery statute 607 says president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yep.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize, and now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through.
Okay. He's asking this because, like, okay, so let's say that a president leads, I'm so glad we're using examples here, okay? So these are really interesting to talk through. One of the strongest legal challenges to this Jack Smith case is that you're saying, so for instance, let's read 18 U.S.C. 371, okay? We did this before we went over these indictments, but if two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do not act to effect the object of the conspiracy, to effect the object of the conspiracy, shall be fined under this title or imprisoned not more than 5 years or both. Okay, so this was the defraud one, and then this last one, or no, wait, the obstruction one is 18 U.S.C. 1512. 18 U.S.C. 1512. 1512. So K and then C2. Not this part. Hold on. C. It's the little c, right? Okay. So it is whoever corruptly, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title or imprisoned not more than 20 years or both, okay? So this is like for official proceedings. And 18 U.S.C. 15C2, I think down here at the bottom of the indictment, I think it tells you specifically how it's charging these here. So 18 U.S.C. C2. Okay. And it's saying that from on or about November 14th, 2020 through on or about January 7th, 2021 in the District of Columbia and elsewhere, the defendant did knowingly combine, conspire, confederate, and agree with co-conspirators, known and unknown to the grand jury, to corruptly obstruct and impede an official proceeding, that is, the certification of the electoral vote in violation of Title 18 United States Code, Section 1512C2. Okay, so this is the U.S. Code that we're talking about. This is the incorporation of that U.S. Code into the indictment, and we see now how Jack Smith is trying to charge this. And before he's going to a completely different place. I'm sorry. I think what Gorsuch is about to say is, okay, what if you were just doing a peaceful sit-in, and let's say that sit-in causes a delay of the vote? Are you going to now criminally charge a president for leading that peaceful sit-in? I think that's where he's going with this, but maybe he goes somewhere completely different. I just waste all the time.
In front of Congress because he objects to a piece of legislation that's going through. And it, in fact, delays the proceedings in Congress.
Is that
now,
obstruction?
Under 1512C2,
Yeah.
That might be corruptly impeding an official proceeding.
And this is the question. So this is the big question about the novel application of the U.S. Criminal Code here is, have you essentially opened the door now to, because of the novel application here, if you essentially open the door to charge every single president who might just obstruct any official proceeding because of, saying something on TV or whatever, are they able to be charged with this law, basically? Yeah.
Is there some importance to those official proceedings?
Now, I'm curious for what Dreeben will say. I feel like this comes down a lot to what corruptly means. And I wonder if this corruptly word, I wonder if that interpretation, the statutory interpretation of corruptly, is going to rely on another crime being charged. So, for instance, does your charge here of under 18 USC 1512 C2, does that charge rely on proving count 1, which is the fraud claim? So, for instance, if you delay something through defraudment, is that what makes this a chargeable crime? I don't know what to say. We'll see what it says.
2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
a president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
I thought you said it, that was my...
He's running through. Let him fucking finish, bro. So I think it sounds like he's running through that Youngstown question. I'm guessing, I don't know. I'm guessing these are what the courts have determined are the Article 2 explicit powers that are unquestionably granted to the president that can never be, like, criminally charged or whatever. I'm guessing, so you'd run through those first, then you do whatever other tests, and then eventually you'd have questions of like, okay, well, we don't have an explicit protection in any part of the U.S. Code or in any part of the Constitution, so now we're going to proceed criminally, I guess. He's trying to get through that, but who is this talking right now? Is this Kavanaugh again, or is this Gorsuch? Oh, no, this is Gorsuch. Okay, Gorsuch just wants to bully him.
A question.
They don't like this because justices have limited time. Oh, okay. I mean, that's important. I mean, it's important for her to lay this out, but okay.
If so, then you may well default to it does not apply, at least on that fact.
I thought you said it, that was my question.
Yes,
and
I
you said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
Yeah. So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of...
Okay, but he's asking, skip all this shit. We understand this. He's asking particularly, what would your protection be then to not... Because intuitively, we wouldn't want to charge a president for a crime there. Obviously. Everybody agrees with that. So what is your protection here, since it's not going to cover under any of these earlier things that this guy's probably about to yap about? What is your covering here for why the president wouldn't be charged with a crime in these circumstances?
Things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2...
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to
violate. Assume he does.
Okay.
Nobody knows what corrupt intent means. We've been around that tree
we will
twice
probably
already.
find out.
And maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from...
Well, let me get to the next layer then, which is that the president does have access to the Attorney General to provide legal advice and regularly gets legal advice from the Attorney General on the lawful scope of the president's activities. We could go down two tracks here. One is that the Attorney General advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the
Nativus form earth and save us, Mother Sphere salvation is not.
Alternatively, the Attorney General could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that, and I would advise you not to violate the
And then he
criminal
could be
law.
prosecuted.
No.
No, if he gets a negative opinion from the Attorney General, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
Well, but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is...
Oh, that's an interesting point that if you ask the DOJ, I don't know if Draven will go here, or if it's just they assume this because they're all smarter than me. If you ask your Office of Legal Counsel and they say, yeah, you can do this, it's fine, and then you do it, how the fuck can you ever criminally convict somebody when the criminal intent can't possibly be there? Where's your devious mind? Where's your mens rea if you've been told explicitly that you're allowed to do this? There is no criminal act here. You thought you could do it. But if the OLC, or your DOJ, I guess, the OLC must be part of the DOJ, right? Or like underneath? What are all these stupid fucking, where's the big structure of all this dumb shit? My guess is the OLC is part of the DOJ, or it's some other parallel office. Is an office in the U.S. Department of Justice? Yes, okay. If your OLC says, no, you cannot do this, you would be breaking a law, then it seems like you've basically satisfied the mens rea requirement right there. It would be a criminal act. You've literally been told, if you do this action, it is illegal. It's against the law. So then if you do it, the mens rea aspect is so easily satisfied. That would be my assumption.
It's whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Draven, can we go back to the bribery statute? I, like you,
Oh, why didn't Gorsuch get to finish there? He got cut off.
understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That's correct. And it's
An
an extremely...
official building. It's a very limited mention of
And it really, I think...
so, as I understand this, there's two very limited...
Draven's a yapper.
provisions mentioning the president as included.
That's right.
There's a whole number of provisions that exclude the president. Many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the fence,
Now, Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think...
That's a tautology you can't escape.
Just Sotomayor, what...
Let me understand this again.
That if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think...
That's a tautology you can't escape.
Is it true? Because the Senate conviction is not criminal proceedings. High crimes and misdemeanors might be called out for convictions in the Senate, but that's based on impeachments coming from the House. I don't know if those would be the same at all. I don't. On its face, I don't agree with that at all. But maybe there might be something I just don't understand here, or I don't know. Maybe I don't know.
Just Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly, that's the point, which is if he's not covered by the criminal law, he can't be impeached for it, for violating it. All right, now...
He's not covered under the criminal law. He can't be impeached for violating it. Do you have to be impeached for violating the law, though? You don't, right?
After impeachment, he could be prosecuted. But under his
You can be impeached for anything, right?
Statutory construction approach, there'd be nothing to prosecute him for.
Exactly, that's the point, which is if he's not covered by the criminal law, he can't be impeached for it.
Yes.
I don't feel like that's true at all. But I must be misunderstanding something. Impeachment. Go back to impeachment clauses for the Constitution. Well, hold on. Article 2, Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. No, actually, this does suggest that. I'm sorry. The plain reading of this means that you would need to be impeached for a crime. High crimes and misdemeanors. So no, she's right. I would hope she is. She's a Supreme Court justice, right? Impeachment is a civil/political maneuver. Impeachment might be a civil or political maneuver, but based on the plain reading here of Article 2, Section 4, you have to impeach based on treason, bribery, or other high crimes and misdemeanors. I don't know if high crimes and misdemeanors is. Let's read the commentary, I guess. The Constitution gives Congress the authority to impeach and remove the President, Vice President, and all federal civil officers for treason, bribery, or other high crimes and misdemeanors. Keep in mind that civil officers doesn't include people in Congress. I think you can impeach, or they can impeach themselves, or there might be other ways of removing them, but members of the House and members of the Senate are not considered officers of the court, as a heads up. This tool was inherited from English practice in which Parliament impeached and convicted ministers and favorites of the crown in a struggle to rein in the crown's power. Congress's power of impeachment is an important check on the executive and judicial branches, recognized by the framers as a crucial tool for holding government officers accountable for violations of the law and abuses of power. Congress has most notably employed the impeachment tool against the president and federal judges, but all federal civil officers are subject to removal by impeachment. The Senate has also concluded by majority vote on various occasions that an official impeached while in office remains subject to trial, conviction, and imposition of the penalty of disqualification even after he or she leaves office. Interesting. The practice of impeachment makes clear, however, that members of Congress are not civil officers subject to impeachment and removal. I believe there's another process for removing members of Congress, but it's not this impeachment thing. While judicial precedents inform the effective substantive meaning of various provisions of the Constitution, impeachment is at bottom a unique political process largely unchecked by the judiciary. While the meaning of treason and bribery is relatively clear, the scope of high crimes and misdemeanors lacks a formal definition and has been fleshed out over time in a manner perhaps analogous to the common law through the practice of impeachments in the United States Congress. The type of behavior that qualifies as impeachable conduct and the circumstances in which impeachment is an appropriate remedy for such actions are thus determined by, among other things, competing political interests, changing institutional relationships among the three branches of government, and legislators' interactions with and accountability to the public. The weight of historical practice rather than judicial precedent is thus central to understanding the nature of impeachment in the United States. But, okay, sorry.
Is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly.
If you love our country and its freedom so dearly, Destiny, why are you not appalled at university protest against homicidal Zionism being shut down? The issue isn't whether or not the protests are being shut down. I think the issue is that the protests are disrupting college classes. That's the issue. Yeah. Hi, what's up?
Hey, what's up? I just saw you were discussing constitutional law, and I thought I'd drop in. If you want
okay. Sure. I've got about an hour and 20 minutes left of this. It's taking me a long time to get through, but did you listen to the oral arguments today for this?
I haven't listened to the oral arguments yet. I just on my channel did a reading of the briefs in this case, though.
Gotcha. How long are the briefs? How many pages?
60 pages each.
Okay. All right. I'm going to continue to listen here.
Try activating the monorail panel again.
Hold on. Oh, fuck. How did I do it? Does anybody remember? There was a way that I did this before. Wait, I know how I did this before. Give me a second. Advanced audio. There was a way that I was able to play my stream audio through Discord.
Yeah, I think you were able to do that before. If not, I can listen to it and mute my mic or something.
Wait, mens rea doesn't mean you intend to knowingly commit a crime, right? Doesn't it mean that you intended to do the thing that is a crime? Otherwise, how come ignorance of the law does not protect you from prosecution? Well, yeah, mens rea is just the state of mind to commit the particular criminal action. Ignorance of the law isn't an excuse. However, it seems to be that you could argue against the mens rea if you had a strong reason to believe that a particular thing was legal, but that's probably going to vary from thing to thing. There's going to be some use cogans or some, I don't remember the Latin term that we use for our courts, but there's going to be some crimes that you're never going to be able to be counseled into. So for instance, if even if a lawyer tells you, yes, you can rape and murder your wife and you'll be okay, I don't think that you can use that lawyer's advice to commit that crime. But I think if a lawyer tells you something like, yeah, you can pay your taxes 3 weeks late and maybe put something different on your IRS form, that you might not necessarily be criminally liable there because you were instructed otherwise and you had a reasonable person. I don't know. On civil law, do you know anything about that?
Specific laws do require knowledge that you're breaking the law. I mean, it's the exception rather than the rule, but I think in the IRS example, you do have to have specific knowledge that you're breaking the law. Okay,
maybe for the IRS example, but I'm sure there's probably some legal thing that if you had no idea. Trespassing might be one of those. Do you know if that's the case? That you can't be arrested for trespassing if you're on land and there was no markings or no signs or whatever?
Yeah, I mean, it would be civil trespass, but not criminal. You'd have to be asked to leave
Sure.
if there's no signs or anything.
Yeah, okay. But I think if you've got to hop a fence or something.
Yeah, they'll do it.
Then okay. So then the mens rea aspect there would probably be satisfied if somebody's literally telling you. So here's two circumstances where I can imagine being informed about something would easily kick it up to a criminal thing. If you walk onto somebody's lawn and it's like a huge fucking 10-acre thing, and somebody's like, "Hey, get the fuck off my lawn," you're like, "Oh shit, okay." Like, let's say they call the cops, or let's say a police officer is wandering by. He's not going to arrest you because you had no way, you didn't even know, right? It's hard to say that you satisfied the mens rea aspect of criminal trespass there. But if somebody tells you, "Hey, look at this line right here. Don't cross this. This is my fucking lawn," and you do it anyway, well, now it seems you've obviously satisfied the mens rea component of criminal trespass because you knew that you weren't supposed to go there and you did it anyway, and with the full intention of committing that particular act, right?
That's right.
Okay, all right. Can you fix the Discord layover? Why is it not working anymore? Wait, what happened? Blame Gisticle. He must have fucked the website up. Reactive by Fugitech. Boom, boom, boom. Right click, refresh. Oh no, it's this. There we go. Okay. Wait, did that work? Wait, can you say something? Oh yeah, okay, never mind, we're good.
This is the power of my voice.
Nice. Okay, OBS advanced audio, monitor audio, set monitor device to something you're not using. It was, okay, OBS, settings. Oh, no, it wasn't in settings. It was right click, advanced audio properties, and then it was monitor audio, and then output it to a device you're not using. Okay, so we would monitor an output, and then I would click this.
Exactly, that's the point, which is if he's...
And then I need to get settings. Oh god, audio. Advanced. The monitoring device would be speakers, USB audio codec, I guess. Apply.
You're right. Except it's underwater now.
It's not covered by the criminal law. He can't be impeached for it.
The good thing is you won't have to go in the water. The Hall of Records is that way.
Oh wait, do I only need the monitor? Monitor only, mute output? I think I need monitor and output. Let me try two things. Okay, wait, I'm going to share screen OBS. Yeah, we'll see. The quality's pretty shitty, but okay. Can you click the listen? I just want to see if you can hear audio coming from my other computer, okay? Let me know when you've clicked it. Okay, cool. Let me know if you... Are you hearing... You're not hearing yourself, are you? Okay. I'm gonna click to play this. Do you hear this at all, or are you not hearing anything? Oh.
It might be best to stay away from the water. Looks like there's
No, wait, nope. I can do this. Hold on. I can do this. I know I can do this. Hold on. Okay. Can you speak again?
Yes, I can.
Okay. Now, are you watching it on my OBS? Tell me if you can hear this.
If he's not covered by the criminal law, he can't be impeached for it, for violating
No,
it.
I can't hear. I can see the volume thing move, but I can't actually hear it.
Okay, that's fine. Hold on. Give me a sec. I can do this. I will do this.
I believe in you.
How did we do this? We did advanced audio properties, monitor and output. And then I watched the thing on Discord. Hold on.
If you shared the YouTube window or whatever it is you're playing from instead of your OBS window, I think the audio would carry through.
I understand what you're saying. For complicated reasons, I can't do that because it's technically the YouTube window that you're seeing over here. This is on a different computer. That's why it's so complicated.
Outstanding.
Yeah. Okay, but don't worry. Hold on. I'm doing this. Okay. We have. Okay, audio is this. Okay, monitor and output is this. Windowed projector preview. And then screen share the windowed projector preview. Really? Is that it? No, that's more complicated than how we set it before. Fuck me. Okay, never mind. I'll fuck with this later. Fuck. I need to fuck with this later. Get this fixed. Don't worry about it. Okay, fuck it. I'm just gonna... You're gonna have to listen to my stream. Is that okay?
Yeah, I'll live.
Okay. If you want, you can just meet me in Discord, and if I say something you disagree with or you think you have more input on, you can unmute and shout at me or something. Okay?
Okay, no problem.
Okay.
All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was to analyze what powers were being given to in the lawsuit, and et cetera. We looked at words, we looked at structure, we looked at separation of powers issue.
Wait, real quick. When we say the APA covers the president, what is the APA here?
The APA is the Administrative Procedures Act. It is the act that governs all the agencies and basically is the rule for rules, how the agencies make rules and do rules. It's the master rule for agencies.
Okay, gotcha. Okay.
Yep.
Issues relating to...
But it does not apply to the White House, because the White House is not an agency.
Gotcha.
We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept a bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context-specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right, could I go back to your brief and going back to what some of my colleagues have asked you? There appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
That's
correct? You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that that have to do with the president in law is that he shall take care that the law be faithfully executed, correct?
That's right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
Well, Mr. Dreeben, presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Did I understand you to say, well, if he makes a mistake, he's subject to the criminal laws just like anybody else?
I hate that question. If he makes a mistake, generally, unless we're talking like strict liability defense or whatever, like we're not usually talking about criminal convictions for people that are like just making simple mistakes. I feel like that's a pretty extraordinary way to talk about a criminal charge, but maybe he'll give more specific examples here.
I understand you to say, well, if he makes a mistake, he's subject to the criminal laws just like anybody else. You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution.
Thank you. Yes, correct. Yes.
There's been some talk about the statutes that are issued in this case. I think they are fairly described as Malaman say statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute that particular application of that 371, conspiracy to defraud the United States, to the particular facts here, but would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
Do you think that do you think all of the court's questions are in good faith, or do you think they ask questions based on premises they don't believe just to see how the counsel will answer? My understanding, and I haven't listened to a ton of these, so I could be wrong, but my understanding is that the question that the justices answer is showing a lot of the ways that they're already leaning in a particular direction. That sometimes just listening to the oral arguments alone are going to be really instructive on figuring out, like, oh well, how are they actually going to rule when that particular case comes down? Because keep in mind that this isn't the very first time that the justices have been exposed to these cases. You know, they've already read all the briefs, they've revealed the lower court's decisions, they've probably done or had their staff do a lot of other reading and research and bringing in like relevant cases. So the questions that are being asked here are pointing in the direction that the justices probably already believe, and they might just be asking for further clarification or asking the person before the court to expand on questions they have that they probably feel strongly about.
It's designed to protect
a
the
lot of
functions
it's just boundary testing as well, trying to ask questions that poke at the extremes to try to figure out where the limiting principles and boundaries of the argument lie, so that you can understand how far it goes.
True,
So
yeah.
it's just you're just testing you by trying to ask how it applies in a lot of different applications.
Yeah. Which is why a lot of these questions have been like, well, if we ruled on it this way, wouldn't the president always be able to do this, or would they never be able to do this? Yeah, a lot of them are limiting questions. Yeah. Wait, are you streaming right now?
No, why?
Oh, just checking. Because if you were, I could link it in my chat. But okay.
I was streaming earlier, but no, I jumped on your stream after my stream ended.
Oh, gotcha. Okay.
Should I stream?
I mean, if I were you, I would. Hell yeah, get that viewership. I would do it.
Okay.
Okay.
I'll throw up an OBS window.
Sure. Okay, I'll go back to listen to this.
Fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest.
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are
Yes. Okay, so that's what I was saying earlier, that your limit here is... So they're saying that, like, especially I think as far as 1512 goes, the idea that, okay, well, you're obstructing an official proceeding, but I think that the 371 part is important here, because just obstructing an official proceeding, for instance, let's say that Obama, or let's say that Biden goes on camera and he's like, listen guys, I just want you to know that my favorite ice cream is chocolate chip Dorito ice cream, and because of that, like, every single person in Congress decides to run out and buy ice cream. The fact that there was an obstruction of an official proceeding there isn't really relevant unless there was an illegal act that precipitated it, or there was some kind of like illegal action that with the intent to cause that obstruction. Showing the intent there, I think, is important to that charge. It's not just like you happen to obstruct something; it's the intentional part that would have to be proven in criminal court for it to happen. Yeah.
to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes, and then Congress in a extraordinary joint session certifies the vote. And the president doesn't have an official role in that proceeding. So
Dreeben keeps trying to talk about the particular case here, but I don't think they were interested in discussing the particular. They were just looking for the limit on this particular power.
It's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function, you can't obstruct it through deception, you can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito? Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
Oh, boy. Oh, no shot. Is he going to talk about the public's perception of improper actions, or is he going to undermine the entirety of the DOJ? Here we go.
Other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right?
Oh, he's going the undermining route. Nice.
Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
I think it's always good to call into question, like, what could a corrupt official do? That's totally fair and important. But I think you have to be careful here because I think the implication that a charge here could be like fraudulent, that's a pretty big claim, because we're not just talking about one prosecutor. You'd be talking about really the entire institution of the DOJ, because it would be, for a case this big, right, the Attorney General is signing off on it, all the prosecutors are signing off on it, all the everybody like relevant to the case is signing off on it. Like, you'd have a huge issue of corruption here, not just merely. So this protection is probably a bit more robust than Alito's questioning is suggesting, but it's still a valid question, I guess, to ask.
Yeah, and I was also, when I was reading the brief, I was a little unsatisfied with the DOJ's brief, because they basically dealt with, in a footnote, whether or not the president could be held liable under state law, because there's something between like 2,300 different prosecutors in this country, and as long as you had a jurisdictional nexus, could you prosecute them within the scope of their official acts? And the idea is that there are certain federal laws that are making those official acts illegal. And obviously you still have to deal with the supremacy clause argument, but it's not 100% clear that you wouldn't be able to find some prosecutor on some state level. So I'm not sure it's necessarily just the DOJ. And even if it is just the DOJ, when you're switching between parties, you're replacing the entire upper leadership of the DOJ with a new political party. And you're replacing every single U.S. attorney, all 94 of the U.S. attorneys, with new people. It's common for the president to fire all the U.S. attorneys and get new ones. So I don't think there's as many institutional barriers as the DOJ likes to suggest.
Is that normal that when you swap out your attorney generals, you're swapping out all of the attorneys as well beneath?
Yeah, it's pretty typical that the president fire. I'm pretty sure Obama did, and I'm pretty sure Trump did. There's the U.S. attorney for each of the district. There's 94 federal districts, so there's 94 U.S. attorneys, and they're all political appointees. So it's not uncommon for the president to fire them all and hire new people completely.
Gotcha. Okay. Josiah says they all usually resign as a custom. Okay.
That too. Yeah.
Well, I'm going to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer is one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the department...
Hold on real quick. You might not be able to stream me on Twitch. I don't know if they changed their rules on that, because I'm technically banned from Twitch. So you might only be able to stream on YouTube, just as a heads up.
Fair enough. I'll stop streaming on Twitch. Fair enough.
Okay.
Office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the...
There were others. A. Mitchell Palmer is one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah, I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand jury.
So Dreeben is kind of using my argument, and then Alito is using kind of uncivil laws argument. And Dreeben is saying that, well, if you look at the facts of this particular... So Alito is asking, okay, well, the DOJ, as uncivil law pointed out, has political appointments and everything. And who's to say that they couldn't like corruptly bring charges against a former president or even a current president, and now you have no protections except for the very narrow things defined in Article 2 that the president could do without, fearing prosecution from even ignoring all the states from his own Department of Justice. And then Dreeben's response is basically, well, if we look at the particular facts of this individual case here, you can see that somebody did try to weaponize the Department of Justice, which Trump did, and the Department of Justice actually rebuked him here. The William Barr and then the acting AG and the acting deputy AG. Is it Clark and Rosen? I don't remember the two names of them, but technically they were pushing against him here. So Dreeben is saying that, well, look, if you look at the facts of this case, what actually happened was exactly the opposite of what you would expect, which isn't technically a refutation of Alito's concern, but I mean, it is a specific example of it going a different way that Alito would predict here.
Juries will shield former presidents from unwarranted indictments. How much protection is that?
Well,
Rosen and Donahue, gotcha. Okay, so I'm going to back up a little for this.
I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting game.
One of the things that Dreeben is bringing up here that I think is really important to consider, and Alito's questions in response are good, but some of Alito's questions and some of the questions on the other end, I think, imply that our criminal justice system is either incredibly unreliable, or at the very least they imply that when a high level of politics is involved, that you maybe can't necessarily rely on what their decisions would be. Dreeben's response is to say, I think he's about to explain, and he kind of said here, is like, well, listen, it's an indictment, okay? There is a probable cause standard. A grand jury has to find the indictment credible. The prosecutor has to decide to bring these particular charges. There are steps that happen before any random charges are just brought before somebody. So, we've got a process for this. And Alito is essentially saying, like, well, okay, but it could be corrupt, or maybe it's not necessarily the case every time. But you have to be really careful, I think, going down that road, because it's like, well, hold on. Because as a citizen of the United States, I would feel like, wait, you're telling me that this whole federal prosecution system is so fucked that I can't rely that indictments that come out of grand juries, that they haven't even met, like, probable cause, or I can't rely on that? Wait, well, what the fuck? If it's not good enough for the president, why the fuck am I subject to the same court system? That sounds like bullshit. I think you have to be careful when you go too far in that direction.
I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting game.
There's the old saw about indicting a ham sandwich.
Well, the standard for an indictment from a grand jury is really low. You only need a majority of the grand jury, and they only have to get to the probable cause standard. It's really, really low. So you only have to, it's the same evidence, effectively, that the police make when they arrest. You just have to have a suspicion that this person did it with some evidence that they're responsible. It's an incredibly low standard. So it's
but that's the standard.
For the DOJ not to get an indictment out of a grand jury. It's
sure, but it's also but the conviction standard is much higher, and the DOJ also has a very high conviction standard as well, right? Like 96+%. I don't disagree that probable cause it's not like a huge standard. Obviously, it's probable cause, but I'm just saying that if we're arguing that like the probable cause standard wouldn't protect here from frivolous criminal allegations, well, wait, doesn't that mean the probable cause standard should be changed for everybody? Why am I, as an ordinary citizen, subjected to the probable cause standard for an indictment if a particular politician isn't?
Fair.
Evidence, and they're not going to get out of the starting game.
There's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes, but I think that the other...
Every once in a while there's an eclipse, too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that...
This is oftentimes brought up for FISA courts and other courts as well, where people will accuse... sometimes people will accuse some courts of being a rubber stamp, like, oh, wow, you brought this before a judge, and of course a grand jury said yes. Like, obviously the grand jury is going to say yes, the standard is very low, like, obviously this is bullshit, and the federal courts are a joke because the conviction is so high. But the counter argument to that is, well, of course the convictions are so high, they're not going to bring stupid cases in front of a judge in order to have a jury rule on them, because they know that the standard of evidence needs to be very high for a conviction, so they're not going to waste their time on dumb cases. Now, where the truth is, I'm sure, is somewhere between the two of these. I'm sure there are some dumb cases cases that are brought, but also I doubt they're just bringing any case. Like, if ideally, if you're bringing a case before a judge, or if you're trying to get a charging document, right, you're not just looking for probable cause, even though that's the standard. You're hoping to convict beyond a reasonable doubt. So the evidence that you either have or you hope to gather through the if you're charging somebody, you can still do discovery after. The evidence you're hoping to get is that you hope that you can prove beyond a reasonable doubt. So ideally, that's what prosecutors are working with in the back of their mind, not just enough to get the indictment.
Yeah. I think I finally got the stream set up on my side, so that's good news too.
Okay.
And secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted, and Watergate cemented that understanding.
Yes, the Nixon stuff is going to come up a lot here. I don't understand how you can escape the Ford-Nixon pardon and still come across this, or still come out of that thinking like, oh, well, every president knows that they're completely and totally immune from all criminal prosecution and actions while president. That seems really hard to get away from.
The Watergate smoking gun tape involves...
Or no, just because of Ford's pardoning and Nixon's acceptance of the pardon seems to imply that an ex-president knows that they could become liable for criminal charges, right? That they were always exposed to that, even while president. Seems to be the case.
I think it's kind of a mistake to read too much into that pardon, and as much as the DOJ seems to suggest. I mean, I'm not sure it's an acknowledgement of anything other than they wanted to moot the issue so that they could move on. I don't know that anyone necessarily thought that there was liability. They just wanted to avoid the problem, so they created the pardon to avoid the problem.
Yeah, maybe, but the fact that there's even a potential problem that exists seems to indicate that people are operating with the assumption, this customary assumption that, like, I might be exposed to some sort of criminal liability, no? Because I'm pretty sure that pardon, like, killed the ongoing investigations and everything as well, right?
Oh, surely did, yeah.
So the fact that investigations were happening where you could have potentially been indicted, yeah, I agree with you. It doesn't, like, close the book on it, but it feels like it points more in the direction of, there might be criminal liability even when acting as president, rather than there is no criminal liability. But.
President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Linear that the right have been made specific so that there is notice to the president. I don't think that would have been satisfying.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if
the historical examples that they're touching on and the responses here from the litigator for the special counsel are really important, because what he's trying to demonstrate is when we're charging Trump with a particular thing, we're trying to explain why this couldn't blow up to encompass literally any action a president could take. So when they touch on historical examples, for instance here, the internment of Japanese Americans, they're saying like, oh, well, couldn't this have been a crime? Wasn't this an obstruction against rights or a conspiracy against rights? Like, why would he not be charged? And then the response being, well, look at these other protections that I talked about existed before. You know, he did this on advice of his legal counsel. He did this on the advice of the DOJ. Like, nobody was telling him that this would have been an illegal thing. Like, this could have been under the powers of the president during the wartime as the commander-in-chief. He was protecting the country. That there are a lot of different layers that would have applied in those historical examples that would have shielded them from criminal prosecution. Whereas on the Donald Trump stuff, for his actions, for the federal case, you can't really find those same compelling arguments. So he's trying to draw a difference there in how it would protect future presidents. Because remember, the big thing here that the defense, that Donald Trump is trying to point out, and his legal counsel, is they're trying to say what we don't want to happen, and we should all agree on this. You never want a president who's trying to make a decision in the best interest of the country, not making that decision because it's not in his personal best interest. You never want to have a confliction between a president thinking that he might face criminal liability for a decision that he should make for the protection of the country. And that's what a lot of these kind of like limiting principles are coming down to is, well, what type of criminal liability could the president face if he's making decisions that he is truly in good faith believes he's trying to do for the good of the country?
If the president gets
or even with mixed
advice,
motives, which also presents a problem because the president might have multiple different motives, and some of them might be self-interested as well. So how do you unpack that?
Sure, yeah.
the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the attorney general that something is lawful, is that an absolute defense?
Yes, I think that it is.
That something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine
Really?
that we referred to in our brief, our reply brief in Garland versus.
Really, what?
Huh. You know, it's like if you get an opinion from the attorney general, it's lawful. It's an absolute defense.
Well,
like, really?
he says that, but I'm sure what he means is this wouldn't apply to what's that word? Manus?
Mens rea.
No. Fuck, I keep forgetting this. It's like our domestic version of like use Kogan's. So many times with this fucking term again. I keep forgetting this stupid.
Mala in se.
Malum in se. Are you familiar with that term?
Oh, malum in se.
Yeah.
Yeah, it just means bad in and of itself.
Yeah, like I don't think that legal advice or legal counsel would absolutely absolve him for those types of acts. So, for instance, like I doubt the president could ask the DOJ head, like, "Hey," or the Office of Legal Counsel. I don't think he could say, like, "Hey, can I go and stab this person in the throat because they, flipped me off?" I doubt it would be a defense there. He said yes, but there's no way that he means that. But maybe they'll get into it more. Let's check.
By estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
And so I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department, representing the United States.
Now, don't you think we need to know the answer to, at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the D.C. Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who asserted a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case, those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now,
If an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think I hate this question. I don't like a lot of leaders' questions on this. The unlimited side on the other end, where like you could commit unlimited illegal actions in your last week or two as long as you get out of office where they can impeach you, I think is far more worrisome than this. Like, because the question here, like, Alito asks kind of a good question, but the reality is that, like, in that world, there are so many other things that would happen anyway. So if Alito is implying here that, like, well, if you're worried about losing an election as an incumbent and your opponent can just now prosecute you as soon as you leave office, wouldn't you do everything to stay in office? Well, that type of opponent was coming after you anyway. I mean, like, there's a million other illegal things they could do if you lose the election regardless. Like, let's say that you hit this shielded criminal liability, which they're implying, well, Alito, I wouldn't say Alito's implying you should have it, but Trump is implying that you should have that shielded criminal liability. Let's say that you leave office and then the next president comes in, you're like, okay, whew, well, thank God the Supreme Court protected me from being charged with a crime. Well, say, like, you're literally walking out and then the next president comes in, he just stabs you in the neck. And it's like, well, you can't charge me with a crime, so fuck you. And, you know, Congress isn't going to impeach me because everybody hates you anyway. Well, you have, like, the exact same issue that comes up here. I think that I agree that, no, I don't even agree that this is a serious concern. If this was a serious concern, it would manifest in so many other ways that would just fundamentally break our government. And I don't think that you can protect yourself in written law from every single potential bad act. You can only hope that you've got a good enough system of checks and balances that if somebody is trying to act improperly, you've got other people that will catch it. But,
It's exactly I'll tell you what, though, any person with assault would I would recommend that you pardon yourself on your last day of office, just because every lawyer would always tell you to take advantage of such a thing. It's like, oh, I have an option that absolves me of any potential criminal liability, no matter what it is. Sign me up, man. Let's sign that thing every single day of the week and twice on Sunday, man.
Can you pardon? Can you pardon future uncharged crimes? Is that possible? Do you know?
You can't pardon future crimes, no. But you could pardon yourself for everything that happened while you're in office.
Or, I mean,
do it like
I'm saying
January 20th, 11:50 a.m. Just sign that piece of paper, man.
Yeah, but I'm sorry. Let me be more specific. Can you pardon yourself from uncharged crimes? So let's say
yes.
Okay.
Yes, that you can do. You can pardon for uncharged crimes. That's clear.
Okay, so if you murdered somebody on the 19th, on the 20th you could pardon yourself from it, even if you haven't been charged with it yet.
Correct.
Okay, interesting. Okay. Okay.
Where I mean, as far as the federal law is concerned, obviously.
Wait, what'd you say?
As far as the federal law is concerned, because the president can only pardon himself for federal crimes.
Yeah, sure.
It's the functioning of our country as a democracy. And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you. Justice Sotomayor?
A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
Correct.
Now, putting that aside, there is no fail-safe system of government, meaning...
Yes, okay, she's going to bring this up. I don't think that you can design any system of government that is completely... Well, you could actually. It would have to be a totalitarian dictatorship. The only system of government that would be completely and totally, foolproof from bad faith actors would be dictatorships, because whatever the guy at the top says is, and that would be the way that it's supposed to work. So you can't break that system. But any democracy or any other system that has checks and balances theoretically could be broken by enough bad faith actors. There's no way, you shouldn't even try to design a government around that. You just want enough checks and balances such that your system still works with reasonable speed, but also has enough different layers of protection that any reasonable attempt to do something undemocratic in a democratic system has a very difficult time manifesting. But you can't foolproof it. It is a democracy. By definition, you can't.
We have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail. routinely. But we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through, step by step, all of the mechanisms that could potentially fail. In the end, if it fails completely, it's because we've destroyed our democracy on our own, isn't it?
Yeah, so this is basically, I think what I was kind of saying earlier, that like if all of these other mechanisms are failing, like you're fucked in so many different ways. Like a single Supreme Court decision here is not saving you. If a new president coming into office commits to wanting to murder or do something crazy to the last one, and if enough people sign off on that decision, a Supreme Court decision is not going to save you. I mean, look no further than the idea that theoretically a president could just say, if he's got enough in the Senate to go along with them, like, oh, well, we're going to put 50 new Supreme Court justices on the court who all agree with me. And it's like, oh, well, fuck us, right?
Yeah, I mean, particularly given the National Security Act, the president basically has the authority to assassinate people under the National Security Act, and so if you can get enough people to sign off on the decision, then you're probably good.
Yeah.
If it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law either in his official or private acts.
I think that is an assumption of the Constitution.
Justice Kagan? Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection, that they are core executive functions.
I don't really like that phrasing, like no man is above the law, because it sort of ignores that based on your status or your position that you have rights to do things that other people don't do. I mean, just the simplest example, like you live in a home. You have the right to exclude other people from the home. Like anyone else who comes into your home, you could arrest that person for, breaking and entering or anything else, but you're allowed to be there. So you're exempt from the law because it's your house.
No, because the law, all of that is, things like private property and all that are clearly enshrined in the law. Like your rights and what you're allowed to do there, it doesn't put you above the law at all. You just have different, like, special permissions that are granted to you, but all of this still squarely falls underneath the law, right?
Yeah, well, that's sort of what I'm saying. I mean, the office of the president carries with it a whole bunch of powers because it's the office of the president. So if you were to reach the conclusion that the president, through his official acts, has immunity of the law, it's not because it's above the law, it's because the law itself gives him the authority to do the thing.
Sure.
That's part of the legal conclusion.
Yeah,
so
but that's
really
part
like
of what's...
I don't really like that phrasing that he's above the law, because if he were to do things in his official capacity that other people couldn't do, it would be legal.
Yeah, but I think that's essentially what's being...
I don't like that.
That's what's being argued
That is what's being argued, and I don't like it.
Well, but it's important. I think it's important to understand, like, what, like, when the president is acting in his official capacity in a way that can never be questioned, are these just like the narrow things provided for in Article 2, or is there a much broader base of actions that should never be under criminal review that the president can take? Because I think as an American citizen, I would very much feel like the president is above the law if he exists as what is essentially a king that is unindictable for any criminal consequences for things that he does while president. If every single action he takes as president could be seen as, like, in service of the office, that's how I would feel, right?
I'm certainly up for a discussion of what is within his official acts. I think that's a different discussion. But so you have two different discussions perhaps happening. Like, assuming it's his official acts, does he have immunity? And then a separate question of what are his official acts, which I think is also a separate question.
Yeah, but the issue for Trump's counsel here is the argument that he was making is even if you commit clear crimes, when they're conjoined with official acts, the official acts can't even be brought up as part of the charges. So a lot of the questioning in the first hour of this, I'm unfortunately through it, you can rewatch it, but the questioning had to do with, let's say that the president accepts a bribe in order to appoint somebody. Would you consider that an official act? And the Trump's defense says, well, no, I wouldn't consider that an official act, which sounds good. But then later on, the question came up of, okay, well, if you're going to charge the president for accepting a bribe in order to appoint somebody, are we allowed to talk about that appointment at all? And he said, no, you can't even bring that up. Well, then it's like, and then the phrase that was used commonly over and over again was, well, now you've got a one-legged stool. How can you charge the president with the crime of accepting a bribe if you can't talk about what he accepted the bribe for? How does that even work? And it feels like Trump's defense was playing a sneaky game there of like, oh yeah, well of course private actions are bad, but if they're connected with any official action, those official actions are never allowed to even be mentioned in front of a jury because they're unquestionable powers like conferred to the president, which would essentially mean he's above all criminal prosecution when doing anything ostensibly connected to the office of the presidency, I think.
First, on the small category of things that you say have absolute protection, that they are core executive functions.
Yes.
What are those small categories?
Pardon power.
Pardon, veto.
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received a certain diploma, or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more. So
that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects, like directing troops on the field, in which the president's power is completely unreviewable.
Okay, now in the next category, where we've left the core set behind, but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro, I guess the quo actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say like what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes
Wait, I didn't get that.
Appointments to courts of people within certain degrees of consanguinity.
Consanguinity. That's a word.
Blood relation.
Oh, Jesus Christ. Okay, consanguinity. In fact, being descended from the same ancestor. Okay, sorry. Jesus. All right.
Principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a...
Do what?
So yeah, it's used also for like estate purposes. So you're trying to find an heir.
Yeah, I got you.
So like your child is 1 degree and your parents are 1 degree, and then your parents' brother is 2 degrees, and the table of consanguinity. It's great.
Gotcha. I think kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only 2 that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, Does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel. Stevens. It was a key TAM case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate.
Am I dumb? I can't follow any of this. Well, what they're running through now, or what Dreeben was running through before, were examples of one of the arguments that's brought up by the defense by Donald Trump's counsel is the idea that, well, the criminal statutes don't involve the president unless there's like a specific call out for it. And I think Dreeben's counter is that, like, well, that's ridiculous. There's only a few that specifically mention the president, and there are so many other federal statutes that clearly apply and obviously apply. And if you look at the Office of Legal Counsel, their legal consideration and the opinions that they're writing seem to imply that that these legal statutes do apply to the president, and it would be strange to assume otherwise. And then Dreeben right now is running through examples, because I think it's Kagan asked Dreeben, do you think that the court should even consider this, right? Because I think a lot of people are looking to how broad, like, is the Supreme Court of the United States seriously going to answer the question of, does the president have broad criminal immunity in the United States against all criminal prosecution once he's out of office? That's the question. And obviously, it seems like the special counsel wants that question answered, but that's a massive constitutional question. The Supreme Court probably doesn't want to answer it. They're probably going to kick it back, because I don't know if they want to even get involved in this. But Dreeben's trying to make the argument, well, I think you guys should answer it. And then he's giving prior cases. Well, here are other cases where the Supreme Court considered important constitutional questions that weren't even directly before the court. And this has happened before, obviously, too. But that's just what they're running through right now.
Way to enforce the law. Congress by making the law, the current executive by deciding to bring it. And since a building block of that submission.
Who would make the decision if not the Supreme Court? Well, the idea, the hope is that these types of things just don't come before the court. That maybe there's a very narrow decision reached by a lower court saying that, like, well, Trump wasn't acting in his official capacity as president, obviously, or gets defeated for some other reason, and then the court doesn't have to consider it. Just because this is such a monumentally huge fucking question that maybe the court... I don't know, actually, on civil law, how does the Supreme Court decide whether or not they really want to answer a really, really fucking difficult question? Like, how do they make that determination?
So general rule is there's the canon of constitutional avoidance. So the Supreme Court and the lower courts will try to go out of their way where they can to resolve a question on non-constitutional grounds if they can.
Mm-hmm.
And they will interpret statutes if there's a reasonable way of reading it of avoiding the constitutional issue.
Okay.
So assuming they can't do that, so that would be like one of the things they could say is like, oh, the statute doesn't say it applies to the president. So
Sure.
that would be like a statutory construction.
And the answer, I assume, the reason why for that is because you don't want every single year there to be like 50 different readings of the Constitution. You hope that everything is consistent internally and as read by letter of the statutes or letter of the Constitution or the amendments, that the stuff is answerable right there, and we don't have to constantly reinterpret the Constitution, because it would undermine the legitimacy of the Constitution and the court.
Yeah, exactly so. And so if you can't do that, then the Supreme Court will they often kick the can down the road. So you could very easily see them coming up with a decision that's somehow remanding for further decisions and letting the lower court try to take another crack at it. So it's not atypical for the Supreme Court to defer, sometimes multiple occasions, sometimes frustratingly, I might add.
Sure.
But this is a completely novel question. They're faced with it for the first time, and they're be reluctant to come up with a really strong answer if they can avoid it. So.
Yeah. Yeah. Okay.
Is that Congress actually did apply these criminal laws to official conduct. The court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official, unofficial line. And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct, and I think that the D.C. Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
There's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators...
What? Pausing? Did you say something?
No, I was just confused when he was talking about the officials with the DOJ, because the president, when they were talking about, like he was trying to get the Department of Justice to do things, and they didn't want to do things for their own reasons. But the president is, of course, the head of the executive branch, and the Department of Justice does work for him. So even if the Justice Department's like, we can't do that because we don't think it's legal, it's hard to say that action is somehow implicating the president in a criminal sense. That's a very odd thing. I mean, President Nixon somewhat famously had that's Massacre Sunday, when he fired the Attorney General, Deputy Attorney General, and Assistant Attorney General on the same day because they wouldn't do what he wanted to. But that doesn't expose you to criminal liability.
I think it super depends on what you're asking in particular. I don't know how narrow they're being. I imagine they're being exactly precise with the case. But what Donald Trump was accused of doing in the indictment for the Jack Smith federal case was asking his DOJ to tell a lie. He was asking his DOJ to fraudulently misrepresent the evidence they'd found for voter fraud in order to create a notice that he could send out to the 7 states that he wanted to overturn their elector votes to. I don't think any reasonable person would think that that's a president acting in the capacity as president for presidential policy. It was very clearly a personal, private ask that he was demanding of his DOJ that wasn't serving in any good capacity. If indeed that was a fraudulent request, which I mean is what the indictment is charging. Hold on, I gotta run. I'll be right back. Give me like 2 minutes. 1 sec.
Okay.
My stream can hear you, so don't say anything you don't want my stream to hear. But you can chat with them.
Okay.
I scanned the credentials.
How y'all doing out there?
Let's look around the Victory Monument first.
For those of you who are curious, my name is Kurt. I have the channel Uncivil Law. I do legal analysis. I hope you like it. We're going to do an oral argument react to this case a little bit later when they have the synced transcript with the audio. Oye does a synced transcript that makes it a little bit easier to follow, so we'll cover it again later. Should be fun. We do Supreme Court analysis, Court of Appeal stuff. Good stuff. So if you like legal analysis, you can check that out.
Oh, it's the code to the
I'm also working on my own Supreme Court petition right now for a cert petition. It's my first one I've ever tried to write myself. So I'm pretty excited about that. I can't really talk about it in great detail because obviously it's still in the stages of being filed. But I'm representing a veteran who was arguably discriminated against in the workplace. And so she has lost at all the levels of appeal below. And so I am writing her Supreme Court cert petition as we speak. So that's exciting for me. And so if the Supreme Court grants my request, then I guess one day I'll be arguing in DC, and that will be fun. How do I fancy Trump's chances in court? I think that he's likely to get relief in his favor. The degree to which he's going to get relief in his favor is questionable, but I think he's going to come up with some kind of a win from the Supreme Court. I think that Destiny was probably right, though, when he was suggesting that they will kick the can down the road. I think that's a pretty likely result. What are the odds that it happens, that the Supreme Court grants review of my case? About 1 out of 160, 1 out of 170, give or take. The Supreme Court grants something like 0.6% of requests. So, yeah, about 1 out of 160 chance of the Supreme Court saying yes, give or take. Although if they agree to hear my case, I think I have pretty good odds of winning on the merits. So that's good. What do I think of the Jan 6 defense? They didn't know the Capitol building was the Capitol when they protested. If you don't know the Capitol building is the Capitol, you are just too dumb. What did you think that big building with the dome on it exactly was? You're too stupid to have the protection of law at that point. If you want to argue you didn't know that Congress was having a joint session, then okay. If you don't know the big building with the dome on it is where Congress meets, I don't know what to tell you. That's just too much, man. The dome was the Pentagon. The Pentagon does not have a dome. Also, the Pentagon is in Virginia, although it has a Washington, D.C. mailing address. There's a fun fact for the day. The Pentagon is also in the shape of a pentagon. That is a clue, yes. Do I like or dislike sporks? I'm not the hugest fan.
All right, sorry, I'm here.
No worries, we're good. We're having fun.
Good, glad. All right.
Check out on some
Election
law.
Like are private, but for an incumbent president to then use private end, and many of the co-conspirators alleged in the indictment are private, but for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, this occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were...
Oh, yeah, that is what he's talking about. Okay, yeah, should have just no longer. But
okay, I gotta pee. Give me a sec.
Like asking the DOJ just to do things, but it was that specifically they were fraudulent asks.
Serious election irregularities, and that they should investigate who they certified
Yeah,
as
but I
president.
mean, they also are his. I mean, they're the lawyers for the executive branch. So whether or not he knows that, I mean, didn't they say earlier as part of the argument that the president has all this wonderful legal counsel, and so he has all these wonderful lawyers, and so he says to them, "Hey, can you do this?" And they're like, "No, we can't. That's fraudulent." It's like, oh, okay, well, thanks for the legal advice. I mean, wasn't that part of their rationale about why the president should be prosecuted earlier?
But that's not what happened. If the president would have said, hey, can we do something illegal? And they would have said no, then that would have been the end of it. But the problem was the president was saying, hey, I want you to do something that we all know is not legal. And then when they refused, I think it was when Rosen and Donahue refused, Trump sent Clark over and said, listen, if you guys don't do this, I'm going to just fire both of you. And Clark is going to be my new acting attorney general. And I think like half the White House staff or half of his like inner circle threatened to quit if that would have happened. And it eventually.
Matter of fact, I'm gonna go brush my teeth and pee. I'll be back.
Asking his legal Justice Department a question. It was more him saying, I want you to do something that we all know here is illegal, and if you don't do it, I'm going to
No. No kitty cuddles, I'm too busy playing video games. Fuck, I didn't press fucking play.
I'm going to start firing you guys until I find somebody who will, which I think is substantively different.
Okay, fair enough.
None of this was true. The Department of Justice officials all said this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege, but how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer the question, was he acting in the capacity as office seeker or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations, and the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought the Blazing Game framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blasingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what nuance you're suggesting.
So Blasingame adopted a generally very favorable pro-government framework that we endorse in private civil cases.
Yeah.
Okay, not here, because we don't think that Fitzgerald applies in the criminal context.
I understand that,
okay.
but putting that aside, the distinction between official act and private office seeker,
yes.
Their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder.
Yeah.
I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I need you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay, but the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay, all right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at the motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of
That's
motive.
right.
Okay.
That's right.
All right, so then we're in the non-core powers where we're fighting over. What role do motives play there? I mean, one could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court, in cases like Myers and Seal of Law, has regarded as having a constitutional status of being removable at will, from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with, at least in part, a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
well, all right, intentions. I mean, you can frame a motive as an intention and intentions as a motive, as you well know, every day of the week. So let's put that aside.
I understand. We're putting that aside, that really to me falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable and others that aren't. I mean, it's awkward, right? When we look back at like the injunction, back to Marbury in the early cases, you can't enjoin a president.
Yeah.
Also, you can hold him in contempt. Right?
A sitting president.
For sure.
Just can I try one more time?
Well, let me just spin this out just a second, right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald. That's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts?
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the agents.
Yes, and I think I would start by looking at the statutes and seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States, the statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512c2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving...
Does it seem weird to be primarily focused on future rulings? Shouldn't we be focused on Trump's case primarily?
Oh no!
Yeah, no.
Not the Supreme Court. The Supreme Court's always got to think about what happens next, and it's a good thing for lawyers generally, and our system of law. We have a common law system, which means that we build on top of the decisions of what happened before, and you can see that influence in any number of decisions. So you've got to be thinking in the long term about how these decisions will impact people in cases far beyond what's going on. If for no other reason, then you don't want to have a Trump rule. You want to have, if we're going to have a rule of law, we need to have a rule of law that just so happens to apply to Trump, but also applies to any number of other people. You don't want to have a Trump exception. So you got to think about the broader set of cases.
Yeah. And then also, like, the Supreme Court, this is the highest body in determining whether or not something complies or comports with the United States Constitution. So the Supreme Court has the final answer. So whatever they say becomes the legal precedent until a future Supreme Court changes their mind or until an amendment is passed in Congress to essentially change the Constitution. So usually when you're making these rulings on these cases, the future precedent or the precedent you're setting for future cases is like arguably the most important thing you're considering, unless it's a very, very, very narrow ruling, basically. But obviously, this ruling in criminal immunity for future presidents and everything is a monumental, a huge decision that the court is tasked with taking up. So yeah, you absolutely need to be concerned with how this is going to impact everybody in the future.
A consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Okay, thank you, Mr. Creed.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produces in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
Well, I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. No, I was just saying this is kind of the mirror image of that, is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. That would pollute the legislative process.
I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes. Hugely
Unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary, because in some of these...
Sorry, hold on. Okay, somebody had an interesting question on Destiny. I'm trying to figure out why they apply this post hoc charging as setting a bad precedent when being impeached is a thing a president has on their mind when practicing their discretion, or what? Do you have a response? The difference is that the getting an entire impeachment through is a far more rigorous process, arguably, than even a criminal conviction. So the chances of being impeached and then convicted in the Senate are lower than probably even a criminal conviction or criminal court. And two, the worst thing that can happen to you as a result of a Senate impeachment, a Senate conviction after an impeachment, is that you're removed from office and you can't hold a future office. Arguably, these are less penalties than what you could face in criminal court. So a president should be worried about being impeached. Everybody should be worried about removal from office in a democracy, because if you're not performing your duties well, then, I mean, we can remove you from office as a democracy. It's part of what we do here. But there's a fundamental difference between removal from office via an impeachment versus criminal liabilities, which involve almost definitionally deprivation of your freedoms guaranteed to you in the United States. The difference.
Yeah.
Instances
like you want a public official to be worried about being impeached, because that's like part of their jobs. You don't necessarily want them to be worried about like criminal things for doing their ordinary duties, basically. Yeah. Sorry, God.
Yeah, and as Destiny sort of alluded to, the threshold to get convicted is so high. With 2/3 vote, you need a lot of your own party to vote against you. With the president, that's going to be unlikely, and except in the most dire circumstances. I mean, even in when they were kicking George, Soros' name out of the House? The House guy
Santos or whatever?
Santos, apologies, not Soros, Santos, I apologize. George Santos, when they were kicking him out of the House, it took like 3 times to get him kicked out of the House because of how much of a political blow that was to get members of his own party to vote against him. And then when you're talking about the president, the political ramifications of that are even so much more obvious. Yeah. So, whereas opposed to getting indicted, you just need a prosecutor and you need a grand jury, which is fairly easy, and you just need to find some sort of criminal exposure. And the U.S. government long ago gave up trying to even count how many federal criminal laws there are, because when you count all the laws and all the regulations and all the incorporations, it becomes a nest. So you can just sit down and find someone who is, something that you did. And also just a friendly, I appreciate the chat that's here and is so nice to, it's been so nice to me. I appreciate them. They're very, very kind to me. So thank you.
Nice. Okay.
When the president takes such actions that, the court's been asking you, might this result in criminal prosecution, you say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function?
And therefore, I acted lawfully.
Therefore, I acted lawfully and
Yes.
am not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get out of jail free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes it's actually an exception to liability itself, and what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defense.
Well, just so I understand this, when we say interlocutory appeal, are we talking about like dismissing a charge as like a pretrial matter? Is that what we're essentially talking about?
All interlocutory means is that the appeal is ongoing while the trial is still ongoing. So we're appealing something before the trial is concluded.
Okay.
Some sort of order, some sort of ruling.
Gotcha.
For example, like an immunity, like this issue would be an example. This is all on interlocutory appeal because obviously the trial hasn't concluded yet. Trump has neither been convicted nor acquitted. It's an interlocutory appeal because if he does have immunity, then the trial should never happen. And obviously you can't fix that after the trial's over because the trial's happened.
Yeah.
So you have to hear it. You have to hear it now. So interlocutory just means that you're in the middle of trial. That's all it means.
Gotcha. Okay.
Yeah.
Offenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions, because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many state and local jurisdictions across the country. What do you have to say to that?
So that raises a supremacy clause issue, and the court would run a supremacy clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions and would then kind of move through in renagel where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the Supremacy Clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean,
Well,
that's my point. Like, you know, it's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of the system, one thing that we have to worry about. That might not carry the day, but, you know, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So Amy's questions here are very good. And on civil law, I think earlier kind of hinted to this, that for Dreeben, a lot of the arguments that that Dreeben is bringing up is saying that, like, okay, well, listen, sure, there are ways that we could conceive of this being abused, but like they brought up how the independent counsels used to work in the past and how a lot of that is in-house under the DOJ now, and how there's a lot of, like, inside the DOJ, there's a lot of oversight from the Attorney General, and look at these wonderful systems of checks and balances, even theoretically built into the DOJ and federal prosecution that would prevent these things from happening. And then Amy's saying, like, okay, sure, let's assume that all of that
Why
is
is he
true.
calling her
So we're not going
Amy,
to grant
bro?
immunity because in the DOJ, you guys can protect against this. But what about the fact that we have 50 different state courts that might find some nexus between some violation of rights or whatever? Now, all of these courts could theoretically hold former president to stand trial for criminal charges. And they don't have all of these same protections that you're talking about that might be built into the DOJ. Well, what's your answer to protect from, I don't know, would you call it frivolous criminal lawsuits or politically motivated criminal lawsuits in all of these independent states?
Yeah, I mean,
So,
that's,
like,
that's a real problem because the president is doing actions everywhere, and so every single county has a prosecutor, and there's a lot of people with potential motivation to make a name for themselves as long as they can find some kind of jurisdictional nexus.
Yeah.
So they try to say, well, look, the Supremacy Clause, the federal law is supreme and the states can't interfere with the federal function. I'm like, yes, that's true as far as it goes, but you're the ones, DOJ, right now, who are trying to say that the president doesn't have absolute immunity from the criminal law. And so if there's a state law that somehow, at least theoretically, it could be the case that the president's doing something for which there might be some state exposure, which the Supremacy Clause analysis would suggest otherwise, and so now potentially
You shall
state
not
prosecution.
pass.
So what are you going to do about that? And as I said, I was really disappointed in the DOJ's brief because they dismissed this literally in a sentence in the footnote. And I was like, that is just like, that's felt so thin.
All right. Resuming.
Purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of Supremacy Clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Yeah.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient.
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, you know, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components, as alleged in the indictment. Working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling calling senators and saying, please delay the certification proceeding, is private campaign activity. We still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for
Yikes,
their
fam.
evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth. And once that has been overcome, we submit that the evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something...
I thought these are decent answers. So just to summarize these, like, people are saying, like, or Amy's asking, like, well, aren't we running the risk of criminalizing, like...
Why does he
behavior
keep
that
calling
will
her
criminalize,
Amy?
And I guess the response is basically that, well, you know, there can be things that we want people to have immunity from criminal liability for, but these can still be considered in a courtroom as evidence towards intent for something else. So maybe theoretically, I'm just going to use hypotheticals. I don't know what the actual laws are, but like hypothetically, let's say we have a law saying that a senator can never be convicted for a speech that he gives from his own lawn. Okay, you can never convict him for that speech. So he can go on his front lawn and he can say something like, "Oh, tomorrow, I am, with full knowledge and malintent, I'm going to kill my political rival." And then let's say the next day there's a car accident that happens and he kills his political rival. The argument would be, okay, well, you cannot convict him for the speech that he gave on his lawn. However, the jury should be allowed to consider the conduct on his lawn, not to hold him criminally liable for what he said, but to use that speech to inform the intention of the other act, is essentially what's being said here. So we were saying that there are certain acts that the president, that Trump here in this case, maybe he wouldn't necessarily, or other officers of the court, or other elected members of court, of Congress, you wouldn't hold them criminally liable for them, but we should still be allowed to put this type of behavior in front of a jury and have them consider it as an intentional part of another behavior. Because the January 6th indictment from Jack Smith here incorporates a lot of different things that Donald Trump did and statements that he made, maybe some even in his official capacity, that maybe you wouldn't hold him culpable for these, but they go to illustrate, like his conversations with Pence was brought up, the intention that he had behind the other actions that they do want to hold him criminally liable for.
Yeah, I mean, you can analogize it other ways too, like just speech that is protected but informs, you know, your intent or lack of ignorance of a defense. You know, that you say, well, I didn't know that, you know, I was doing X, Y, Z, but you had earlier said something that indicates that you did know that. So you're using the purely lawful speech. It's like, you know, I can't go to the restaurant. It's closed at 9 p.m. And then, you know, forward later, it's 11 p.m. and suddenly you're in the restaurant. It's like, I didn't know they closed. I just thought they were open. I wasn't committing burglary.
Yeah.
So you're using the earlier speech to prove the absence of mistake.
Mm-hmm. Yeah.
So that kind of thing.
We submit that evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient allegations in the indictment, in the government's view, that fall into the private acts bucket that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one? This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to...
Right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president or, can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to...
Yes, please.
But the first step is there ambiguity? And these statutes apply to any person. They apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution or does he have immunity is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in either the existing doctrine or the text. And just one data point for the court in thinking about how the clear statement rule works. In United States versus Sun Diamond, in a case about gratuities...
I don't understand her confusion.
Well, I don't know what the point of this question is. It sounds like she's saying that, like, generally we try to read statutes narrowly so that we're not having to ask a very difficult constitutional question. But in this case, we basically have to answer a really difficult question. I don't know why she's asking it. Like, obviously, that is what's before the court. So I don't know why she's asking it.
Because, I mean, this idea of this clear statement rule is we're going to assume the statute doesn't apply to the president unless Congress makes it clear that they want to apply to the president. And the reason that we're going to make that assumption is because if we assume it doesn't apply to the president, then we don't have the problem of potentially Congress interfering with the executive branch. We don't have the inter-branch conflict. So we're going to interpret every statute as not applying to the president because that helps us avoid the constitutional question. Now, in a hypothetical where Congress wrote, no, we want this to apply to the president. Well, in that hypothetical, now we can no longer avoid the conflict. Now we have to say, okay, Congress wants this to apply to the president. Can they do it? We have an unavoidable conflict. We have to answer the constitutional question. So I don't understand her point because it's like this, the clear statement rule is one way to avoid the conflict. It's like, all right, we can avoid the constitutional question about whether or not the president is immune by simply saying Congress didn't apply this to the president. It solves the conflict. You don't have to answer the constitutional question. You root it in statute. Congress didn't make it clear. We all go home without answering the constitutional questions.
Well,
so
but haven't you kind of have answered the question?
confusion.
If you do that, you kind of have answered the question, though, haven't you? Because now every single prior statute that doesn't make it clear essentially doesn't apply to the president, and in a way, we've kind of answered it, right?
Yeah, we've made it clear that every single statute, except the few that explicitly mention the president, don't apply to the president.
Yeah.
So, yeah, that solves that problem. But we root it in Congress not being smart enough to put it in the statute, which, strictly speaking, makes it a statutory problem. So, I don't know. I'm not sure I really like this idea personally. I don't think it's the right way to solve the problem, but it's a proposal, I guess.
Sure.
Familiar with. Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law unless the president is specifically named, which he is not in Section 201, Justice Scalia would have thought of that and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines. Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about Glassingame, and that within first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, at what level the president is going to have immunity. But I took the petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity, and so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question, the way that the government has submitted that resolves the case. I want to make a clarification that I may have left the court with some uncertainty about. The official act analysis that my friend is talking about is the Fitzgerald versus Nixon outer perimeter test, which is extremely protective of the president. It's not looking at core versus ancillary. It's saying everything the president does is a target for private civil lawsuits. That's not a great thing, and therefore they are all cut off.
That's an absolute immunity kind of concept, right? Anything that's official in the outer perimeter is not subject to liability.
That's right.
And so we don't have to then go, well, okay, we have.
Well, careful though, unless I'm misreading this or misunderstanding this, what they're talking about, that only applies to, I believe, civil matters, right? That doesn't shield you from criminal liability. It was just for private cases, right? Okay.
That is the precedent, sure. Yeah, they're trying to extend that out to the criminal law. But as I sort of pointed out, this idea of the absolute immunity applying to the criminal context has been the understanding of the law as it relates to prosecutors, for example, and judges, for example. And then you get into the idea of it not being within the scope of their official role. For example, bribes is not within the scope of their official role. But absolute immunity as a criminal immunity is not a novel concept. So, yeah, that's what they're talking about.
The bucket of official, now let's figure out which within that might be subject to liability, not on the theory of absolute immunity, correct?
Neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity, but this is where I would draw the distinction. There are as-applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine whether there's a infringement of Article 2.
So what you're saying is even if we reject the absolute immunity theory, it's not as though the president is, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out the line, is this the right vehicle to hammer out that test? I mean, I'd understood that the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
I don't see any need in this case for the court to embark on that analysis.
All right, the final sort of set of questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing. But I wonder whether some of it might also be mitigated by the fact that existing administrations have a self-interest in protecting the presidency, that they understand that if they go after the former guy, soon they're going to be the former guy, and they will have created precedent that will be problematic. So I wonder if you might comment on whether some of the caution from the Justice Department and the prosecutors and whatnot comes from an understanding that they will soon be former presidents as well.
I think absolutely, and I would locate this as a structural argument that's built into the Constitution itself. The executive branch, I think as this court knows, has executive branch interests that it at times asserts in opposition to Congress so that the proper functioning of the president is protected, and I believe that that value would be operative and is operative in anything as momentous as charging a former president with a crime.
And I would also say, I think, and ask you to comment on, presidents are concerned about being investigated, and prosecuted, and it chills to some extent their, ability to do what they want in office. And that's a concern on one side, but can you comment on the concern about having a president unbounded while in office, a president who knows that he does not have to ultimately follow the law because there is really nothing more than, say, political accountability in terms of impeachment? I mean, we have amicus briefs here from Professor Lederman, for example, who says, a president would not be prohibited by statute from perjuring himself under oath about official matters, from corruptly altering, destroying, or concealing documents to prevent them from being used in an official proceeding, from suborning others to commit perjury, from bribing witnesses or public officials. And he goes on and on and on about the things that a president in office with the knowledge that they have no criminal accountability would do. I see that as a concern that is at least equal to the president being so worried about criminal prosecution that he, is a little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has seen occasional episodes of presidential misconduct. The Nixon era is the paradigmatic one. The indictment in this case alleges another. For the most part, I believe that the legal regime and the constitutional regime that we have works, and to alter it poses more risks.
Thank you.
Thank you. Thank you, counsel. Rebuttal, Mr. Sauer?
I have nothing further, Your Honor.
Thank you, counsel. Counsel, the case is submitted.
The Honorable Court is now adjourned until Thursday, the 9th of May at 10 o'clock.
Wow.
Just want to.
Well, there's your oral arguments for this case. People are saying, or the predictions, I don't 100% know why, but apparently they're just going to kick it back to the lower court and ask them to rule on something more specific rather than ruling broadly on this. But I guess I feel like Dreeben, I think, made obviously superior arguments to Trump's counsel. I think Sauer's position is entirely untenable. I think the broad criminal immunity is it would be a wild precedent, and I don't think the fears of infinite criminal prosecution, I don't think they're very well-founded fears. But yeah,
I did appreciate that mic drop right at the end, though. I have nothing further to say. So that's pretty good.
Yeah.
It's bold.
Yeah. Well, any other final thoughts or?
No, I think it just presents. It's a very interesting and complicated question because you want to on the one hand make sure that the president, along with everyone else, is upholding the law. But I think that these concerns about the president being tied down or concerned about prosecutions from his political rivals is a strong concern. If for no other reason than it seems lately that, in each election we are told that this is the most severe election and this is the worst president of our lifetime. And so the political incentives and doctrinal incentives for one government to go after the other is very large. And I think we've seen in other countries of the world, including in the modern era, how that can sometimes manifest with, every former president or person of equivalent station just being prosecuted by their new political rivals. And we don't want to run into that situation where it just seems endless and, just seems completely something that people are taking advantage of for political expediency. So
yeah,
I think the concerns on the other side are somewhat real.
I think that's a real concern, but I think that concern is dramatically overshadowed by the concern of a president having unlimited criminal shielding in his final days in office. I think that would be an unbelievable precedence that there's just absolutely no criminal liability for any action that a president does in office, assuming he's not going to get impeached. I think it would turn fundamentally the understanding of rule of law in this country, I think, on its head. I don't think any of the framers, deciding what a president is like, who's very much not a king, would have had that in mind. I think the challenge is that you're dealing with an unprecedented ex-president who's taken relatively unprecedented actions. So any rule you craft here seems very scary. But I think that people underestimate the scariness on the other end as well, and how many different parts of the government had to hold to prevent Trump from essentially coupping the incoming regime. Yeah, and that's it's pretty spooky to me. But
no, I definitely think there's legitimate concerns to be had, but the idea that some prosecutor, we've already heard the claims against Biden, and the degree to which you think those are important, I suppose, depends on your political predispositions. And the idea that we won't just end in an endless cycle of investigations and recriminations seems problematic. So
don't we already do that in Congress anyway, though? Like with the Hillary email thing, with the Jim Jordan impeachment thing, with the Russiagate thing, with the 9/11. Like we already have ways in Congress that this can continue, even absent criminal stuff.
Well, I think Congress is, if nothing, is a cautionary tale, because was pointed out as well in the briefs. We had one impeachment, Andrew Johnson, and then we've had 4 different impeachments in the last 20 years or something like that, possibly 5 if we count Biden's, which hasn't been formalized into an impeachment yet, but seems to be heading in that direction. And we are heading into this. It seems like we're endlessly impeaching each other, and the endless investigations in Congress are a cautionary tale, because it's like once you open this door, it seems in our modern era, it just never stops.
Well, I guess the question would be:
I appreciate that's what's happened to Congress. I would just appreciate if it doesn't also happen to my judicial branch.
Yeah, I guess the question would be: do we feel like any of the recent impeachments were bad ones? Like, should Clinton have been impeached for lying under oath about Monica Lewinsky?
Well, I think it's a pure political question, because I think Congress can kind of do whatever it wants, because Congress is the sole judge of its own rules.
Well, but if somebody were to impeach somebody for having a small dick, I think we would both agree that it's probably not a good, regardless of our political leanings, right? I feel like the impeachment of President Clinton, I think, was fair. We can argue, I guess, over the impeachment of Donald Trump, but I think the two of them. But I guess the question here doesn't seem to be one of like procedure, which I think is what you're focused on, which I agree. I think it's more of like a political question, and how, and I think it's representative of how divided we are as a country right now for how Americans are feeling about this. So I feel like sometimes in the American system, we're trying to solve like political differences in the country and the population through procedural remedies, which just can't happen. Like whether we give the president immunity or not, whether we impeach or not, they're always going to find ways for our system to break and fuck itself if we are so unimaginably divided, factually in this country against each other, I think.
Yeah, you can't bad faith proof a system. And where I'm kind of curious is, I'm sorry, what's your name? Uncivil law?
My name is Kurt.
Kurt.
My name is Kurt. How are you? What's your name?
I'm Josiah. It's good to talk.
Hi, Josiah. How are you doing?
I'm doing well, man. So I'm kind of curious though. So like, my understanding is, and I think the Solicitor General made a pretty compelling case here, that it was understood since the founding of the country, and I think Justice Jackson said this too, presidents seem to have operated under the impression that they could be criminally prosecuted after they leave office. And I know the Nixon and Ford example, to me, is the standout, because when Ford gave his statement as to why he pardoned Nixon, he made it pretty clear in the statement that he thought that Nixon could be prosecuted. That's why he issued a preemptive pardon, or not a preemptive pardon, but to preempt the prosecution. So you're worried that if they don't grant blanket immunity, that there's going to be a tit for tat here. But we haven't seen that in 230 years. We haven't even seen that since Nixon, right? So why are you so convinced that that would change here? Number one. And number two, the comparison with impeachment. I actually think you kind of refuted it yourself when you acknowledged that impeachment is an inherently political exercise. So there's no real burden of proof. You just need a simple majority in the House, and you need 2/3 majority in the Senate, right? You don't actually, it's not like beyond all reasonable doubt or anything like that. It's not a criminal case. So can you kind of elaborate as to what your fears are about this? And actually, and the last thing I'll say is, other democracies across the planet, Japan, France, South Korea, they have prosecuted former heads of state, and they're still functioning.
Yes. Yeah, I mean, South Korea, I'm not sure how good an example is that, because it seems like every president winds up getting prosecuted in South Korea. But my concern is that the lawfare concern that, no one's tried to criminally prosecute a president before, and you could say that we're on the way to Nixon, but obviously that didn't happen, and now we are prosecuting this president, and it just, I'm just concerned about the precedent, because it seems like the warnings about how this will happen next sometimes get ignored. I remember when Mitch McConnell warned Harry Reid, for example, on the floor of the Senate when they broke the filibuster for the federal judges, how they'd rue the day. And it was only a couple of years later that, they broke it again for the Supreme Court justices using the same logic. So it seems like whenever one party breaks a certain Rubicon, it seems like it's fair game for everybody. And then it's, turtles all the way down. And so I'm just concerned about that.
Well, it's interesting that you cite the Reid example, because, doing a filibuster carve-out for executive and legislative appointments, executive and judicial appointments, which is what happened with Reid and McConnell. There again, number one, that was a political exercise. Number two, Reid repeatedly warned McConnell, because at the time McConnell was cock-blocking Obama's appointees to an unprecedented extent.
This is true.
Literally half of all filibusters and Senate blockages of presidential appointees, half up until that point, happened under Obama's administration, because remember, McConnell famously said, we're going to make him a one-term president. We are going to obstruct every step of the way. And Reid's position was, listen, yeah, advise and consent, but you don't have the right to just literally blanket no to every presidential appointment. If you keep doing it, if you keep acting in bad faith, obstructing, we'll change the rules. So to me,
I'm not sure why you don't. I mean, consent also means not consent. I can just say no because I don't want to.
Right, but if the shoe was on the other foot, how would Republicans have responded? Exactly the way Democrats did, right? Exactly, and we actually kind of saw that in a way. We actually saw that in an aggressive, unprompted way from Republicans when Donald Trump won the presidency in 2017, and Republicans took the majority. They removed the blue slip veto from circuit court judges, just preemptively, to prevent Democrats from vetoing Trump's judicial appointments for circuit courts in those states. So my point is, it kind of goes back to, I don't know if it's Kagan or Sotomayor, who were like, you can't bad faith proof a system. And I take your point that, again, there may be a tit for tat. Obviously, there's room for a tit for tat if this happens. But what's the alternative? That I think Justice Jackson says, the president's already the most powerful person in the world at the time that they're in office. You want to open the floodgates and make that, that power even more unchecked? To me, that's the greater risk. And I don't think, with respect, I don't think that you're seriously grappling with that.
I don't think that's fair that I'm not seriously grappling with it. I have concerns on both ends. I think there's, as I've sort of been trying to work through it myself, I think there's a lot of concern about doing it, and there's a lot of concern about not doing it for largely the same reasons. You don't want to have an unchecked person who can just do whatever the hell they want with no check, and perhaps, to use the DC Circuit's example, they're committing SEAL Team 6 to perform political assassinations, and maybe members of Congress don't want to impeach because they're concerned about them being next and all the rest of it. So you don't want to live in that world. And I'm also concerned about the exact opposite of that with the DOJ's position of just complete exposure to all the criminal law. Because as I said, there's so many laws on the books that even the federal government can't keep count. There was a good book written by a law professor, said 3 felonies a day, which basically argues the average citizen commits 3 felonies a day because of just how many laws there are on the books. And I'm just concerned that the
Wait a second.
motivation...
Wait. What's the source for that? What do we mean when we say that? The average
Silverstein or Silverstein, I want to say.
I'm sorry. I didn't mean I just mean what 3 felonies a day? There's a mens rea component to most criminal matters. What is an example felony somebody might commit without even having awareness of it?
I mean, I don't know off the top of my head, but the idea is just there's so much exposure that if you just try to if you really put your mind to it, you can probably find something.
I feel like there's a lot of exposure to civil stuff for sure, but criminal stuff, or maybe like citation stuff. I don't do you consider speeding tickets aren't criminal matters, right? Isn't it considered something different?
Typically, no, they're not considered criminal.
Yeah, so I mean, but exposures to every citizen is committing felonies. That I find that hard to believe insofar as criminal law goes. That so many people have so much potential criminal liability they're totally unaware of.
Yeah, it was Harvey Silverglate. I was pretty close on that. So if you want to look up his idea on that, you can check that out for yourself at some time. It's been a long time since I read it, but that it's just there's just so much exposure. So.
I was looking here at the D.C. Circuit Court's decision, which preceded this one, and I'm pretty sure there's a passage. And I'm not an attorney, you are. Aren't there laws or protections against fishing expeditions or frivolous lawsuits or things like that? I'm pretty sure it's referenced in the D.C. Decision on this, that's a protection that would be available to Donald Trump or any ex-president if kind of what you fear comes to pass, which is that the next administration from the opposition party would pursue legal actions against their predecessor. Aren't there laws that protect against frivolous lawsuits or things like that?
Sure, there is, but if you can come up with an exposure that makes the prima facie standard, you can get investigation. So as a private individual, sure, because it's harder for a private individual, but the government with their resources and warrants and other things, I mean, it's definitely a problem.
Okay. So the other thing I was going to ask you about, because I don't know when you joined in the conversation, but I know this was obviously not satisfying to me, and I think I heard Stephen say it too, which was, Trump's attorneys took the position during his second impeachment, and I understand, Stephen, there was quibbling over the timeline. Just want to remind everybody.
No, there was no quibbling. We solved it. It was just a fucking moronic shit. Yeah.
I was about to say, they deliberately kicked it out to create this ambiguity in the first place. They could have taken up the Senate trial when Trump was president. They chose not to deliberately. So anyway, during the impeachment trial, Kurt, if you remember, Trump's attorney said, "Listen,
I do remember.
Yeah, that you gotta impeach, or you gotta go after them with the Justice Department if they're a former president, because you can't impeach and convict a former president."
Right,
now
yeah.
Trump is taking the opposite position because, of course, he's an unprincipled hypocrite and would just take whatever's convenient to him at the time. So when that conversation or that tangent comes up during this case, Trump's attorney is like, "Well, listen, that's just a risk we have to assume. If the illegal conduct isn't known about until after the person leaves office, it's just you're kind of SOL." Do you find that satisfying?
Not entirely. No, I mean, it's just there's just a lot of worries that I just, just generally speaking, I just worry about what happens next in the precedent and how things can be manipulated and extended and just added to. So, I mean, I have concerns just on every end of the debate, basically.
Is there anything you'd like to see happen? Like, if you have concerns either way, obviously this is going to be resolved one way or another. There's going to be some sort of court decision. What would you like to see happen?
Well, if the DOJ believes that they can make this case based on just the purely personal stuff without the official acts, then the easiest way to resolve this is just like, okay, then go do that. Because you by your own admission, and we heard them say it in courts, like we can do it just based on the purely private acts. Like, okay,
well, but
it's
a weaker case, though, right?
I mean, it's a weaker case, but it avoids the problem, and if they think they can do it, which it is D.C., where Trump would be charged. D.C. is 92-93% Democrat, so I feel like their odds are pretty decent.
Wait, what was, because I wasn't able to listen to the like final third of it. What was the take on like the one-legged stool notion, which is, if they, the official act for private gain, where was like the final like judgment on that? Like
I don't know if that came up with the questioning on the state side, or it might have come up once. I don't remember that, but yeah, it seemed like a weird part about the defense's side.
Yeah, so that would be my question, Kurt. Like, wouldn't they still have to reference the official act, even if it was for private gain? Like, wouldn't they have to say that Donald Trump abused, his executive authority? Like, wouldn't they still have to make that case? Because I'm kind of confused what you're saying. Like, they said they can make the case without referencing any of his official acts.
Mm-hmm. Oh. Well, like, for example, if they think that this, just the phone call to Georgia, for example, like, if you want to argue that was not an official act, or he calls the Georgia Secretary of State and says, can you find me whatever number of votes it was, that's not an official act, then you can just be like, okay, well, here's the phone call he made, and he's campaigning for office, and he's asking to find votes, and that's has nothing to do with the fact that he's president. It has nothing to do with his official acts. So, there's an example, and I don't know how that would play exactly into the D.C. case, but I would imagine that, with the false slate of electors, it's like, okay, if you want to say that's not an official act, it's like, okay, here's the phone call he made to whoever, and here's the person he conspired with, and here's the person who was one of the fake electors. Like, yeah, but I was recruited in order to be a fake elector and submit fake election documents. It's like, just, that has nothing to do with his official act, so you just do that.
Did they concede, did Sauer concede that him calling Brad Raffensperger in Georgia was a private act?
Yes.
No, yeah.
Okay, so then here's my follow-up question. If they concede it here in front of the court, would they be obligated to hold that position if if Jack Smith does what you suggest and drops like the official acts and goes after the private acts and refiles the case or does whatever he would need to do, is Sauer obligated to take the position? So maybe could Sauer come back and say, actually no, that was the sitting president checking in on election integrity during a national election, that was an official action on his part? Can he
wait, hold on, fuck, some people in chat are saying he didn't.
Okay.
My understanding is he said that he conceded that quite a few things were private acts, but the way that he got around it is he was saying that none of the public gains that they were tied to could ever be brought up in exchange when you were talking about these particular private acts.
Yeah, the one-legged stool thing.
Yeah.
But let's say any of them that he conceded during the argument says, oh, it sounds like a private act. Is he obligated to stick with that if Jack Smith does what you say, Kurt, and refiles
also, wait,
the case?
Well, you can say
yeah,
that. Real quick. I'll be right back. You guys can keep talking.
If it's fine. If he actually made a concession, then yes, he's obligated to do that. He is representing his client, and he's making a representation in the court. They are definitely bound by that representation.
Gotcha. Okay. Interesting. All right.
That is F around and find out on the biggest possible level. Yeah, when you're telling the Supreme Court this is reality, you're stuck with that reality.
So if he told the Supreme Court this is a private act, they do what you suggest, he files again, and then says, actually, no,
it's
that
law.
was a public act.
On a formal level, on a formal legal level, we call it law of the case, right? Because I've made a representation to the U.S. Supreme Court. They're going to issue a decision based on my representation. That now forms the law of the case. And so now that representation, which is baked into the order, is now part of the law of that one case. And so, yeah, I'm stuck with that.
Interesting. Okay.
Yeah.
So what do you think's gonna happen from this? I guess is my last question for you. You think they're going to remand it?
I think Trump is going to come up with some kind of win. Now, what kind of win, I don't know, because I can definitely see the Supreme Court wanting to kick as much of this down the road as they can. So I can see
even a
them
delay
wanting
is a win for him, right? I mean, even if they remand the kid, that's a win, right? Even if it goes exactly the same way, the idea of putting it back to a lower court, that's a win for him because he does not want this to go to trial before the election.
No.
Yeah.
And some trials take a long time to go to trial, and whether or not, and they just sometimes percolate for years, even in non-presidential cases. Some cases just take. I mean, there are murder cases where they're 3, 4, 5, 6 years old by the time it gets to trial, just because of all the preliminaries and everything that happens. Things happen, so we don't typically just expedite it because it would be nice to get this done faster. Due process sometimes requires lengthy time.
Yeah, I don't think even after this, I don't think that they're going to grant some sort of blanket immunity. That would boggle my mind. I mean, even if for no other reason, is that would further remove the president from any sort of judicial review by the Supreme Court in terms of, well, at least in terms of potential criminal prosecution, right? That would further immunize one branch of government from the. I don't think they would. They're going to rule in that way. They might do something like you said to try to give Trump a win here. I have a hard time believing they're going to give him exactly what he asks for.
No, I don't think they're going to.
Especially with the incumbent being a Democrat, So,
yeah.
Cool.
No, I don't think so either. Just a friendly reminder for the chat out there in Destiny's World. My name is Kurt. I have the channel Uncivil Law. I have 129,000 subscribers, trying to get to 150. So if you like legal analysis, legal commentary, legal discussion, that's what I do. Try to produce lots of great content. So head over to Uncivil Law and subscribe today. It is appreciated. Thank you.
Cool.
Got to get the channel plug out there.
Yeah, you should as often as you can. All right, buddy. I appreciate it. Thanks for answering the questions. You have a good rest of your night.
No problem.
Bye.
Yeah, no problem. Yeah, but I definitely think that we're looking at some kind of win for Trump here, and the nature of that win is where the rubber meets the road. But I think they're going to try to kick as much of this down the road as they can. But I think they're going to. I think the president's going to have some kind of immunity for official acts, and it may not be a complete immunity, but it may require like some sort of heightened qualified immunity, where it might require some sort of specific findings or some sort of specific delineations by the trial court. So I think, as a practical matter, the trial court is going to spend a fair amount of time trying to, assuming they're not just cock-blocked, I assume they're going to spend quite a bit of time trying to constrain and filter out what are official acts, what are not official acts, giving the proper instructions to the jury and all the rest of it. That's going to take a lot of time. So I think, as a practical matter, we are not looking at a trial in D.C. reasonably anytime in the immediate future. That is the best possible analysis I can see based on the argumentation. So it is what it is. Would I be willing to do if I'm wrong? Well, if I'm wrong, then I'd read the Supreme Court's decision and find out why I'm wrong. That's what I do, right? When I make an incorrect prediction, I read the decision of the court to understand why I made an incorrect decision and try to figure out whether or not the court's reasoning is better than my reasoning. And if the court's reasoning is better than my reasoning, I'm like, oh, okay, that makes sense. I'm glad that they explained it to me. Now I'm smarter. And sometimes I disagree with the court, and I'm like, no, I don't agree with the Supreme Court. I think that was an incorrect decision. So that's what I do in legal analysis world. I read the decision and I think. That's what I'm willing to do. I'm willing to read it and think. And then, depending on my reading it and thinking, potentially revise my ideas. Yeah. But I mean, just because I disagree with unanimous Supreme Court decisions. Quite famously, I've disagreed with Wickard v. Filburn and disagreed with Chevron versus NRDC, both of which are unanimous Supreme Court decisions, and I think the Supreme Court got it completely wrong. So, I'm not afraid to disagree with the Supreme Court when I look through it all, and I'm like, you know what? I just think those were incorrect decisions. So, That's what we do. Yeah, Wickard v. Filburn is a hell of a case. Wickard v. Filburn, for those of you who might not know, was a case about wheat and how much wheat you could grow. The United States had a law that restricted the amount of wheat you could grow. The reason they had this law was because they were guaranteeing the price for wheat as part of an economic measure. So they said, we will guarantee that we, the federal government, will pay X price for the wheat. And then, well, they're like, well, if it's uncapped, people will just grow as much wheat as they possibly can, and we'll have an uncapped thing, and that's bad. So they're like, okay, here's the maximum amount of wheat you can grow. So this guy, Filburn, owned a farm, E-I-E-I-O, and on this farm, he grew some wheat, E-I-E-I-O. And critically, he consumed all the wheat on his farm. He didn't sell any of the wheat. He used all of the wheat. Okay? He used all of it. And so the wheat man came by and it's like, yeah, you're growing too much wheat. And he's like, but I consume all the wheat. And they said, well, you can't do that because we can regulate it under interstate commerce. And he's like, dude, this is a farm. And I'm not selling the wheat. It's not interstate. It's a farm in a state. It's intrastate. And it's not commerce. I'm not selling it. It's non-commerce. So instead of interstate commerce, it's intrastate non-commerce. And the U.S. Supreme Court ruled that he could not grow the wheat. They ruled that the intrastate non-commerce legally counted as interstate commerce because since he was growing the wheat, he wasn't buying the wheat. And because he wasn't buying the wheat, well, that affected commerce now, didn't it? So that not buying things counted as commerce. That was Wickard v. Filburn, 9-0. I hate it. I hate it with a passion. Yeah. Because, you know, if everyone grew their own wheat, well, then people wouldn't buy wheat on the market. People wouldn't go to the store and buy their wheat because everyone's buying wheat. And we need to have a wheat market, so we need to make sure that people buy wheat. So you're growing more wheat than you're allowed. And if you need the wheat because you consume all the wheat, you have to go onto the market and buy the wheat you need. You can't grow it. You're not allowed to grow your own tomatoes or wheat or whatever. That was Wickard v. Filburn. I hate it. I hate it with a passion. Yeah. Yeah, it pisses me off. U.S. versus Lopez, that's the gun control case with the guns near the school zone where they tried to regulate interstate commerce. U.S. versus Lopez was the first case that did not uphold a law under the federal government's interstate commerce authority, like ever. So Wickard v. Filburn was the late 30s, I want to say, and Lopez was like 92. So, Lopez was the first time that the U.S. Supreme Court said the federal government did not have authority under interstate commerce. In Lopez, the federal government tried to ban trying to ban having handguns near schools, because having handguns near schools affected commerce. Because if there were guns near schools, then that might affect the ability of the kids to learn. And if the kids don't learn as well, then they might not be as economically productive, and that would affect commerce. So they tried to create guns-free school zones under interstate commerce. The possession of guns was part of commerce. And the Supreme Court said, no, that went too far. That was Lopez. Give us another example of a Supreme Court decision I don't like. Well, there's one right now that's being challenged as we speak that I hope will die a horrible, horrible death. Chevron versus NRDC. Chevron versus National Resource Defense Center. Chevron is the backbone of basically all administrative law as it exists today, and I hate it. It basically says that the administrative agencies are the ones that get to interpret what the law means, which doesn't make any sense, because you have a federal agency, say, I don't know, the USDA, and you ask, and here's a law, hey, USDA, here's what we want you to do. And then you're like, okay, so what is the USDA allowed to do? And guess who gets to make that decision? The USDA. The The USDA is the one that gets to interpret the statute that tells them what they are allowed to do. And amazingly, they interpret to give them more power. What are the odds? So every federal agency is the one that gets to interpret what they think the statute means. And then there's some follow-on cases called Our is one, A-U-E-R, Our, and then one is called Brand X is another case. So they get to interpret what the statute means, they get to interpret what their own regulation means, and they get to change their mind. So they can completely flip their mind about what the law means, and they're still right. So it's the person you gave power to that gets to interpret how much power they have. That's Chevron. I hate it. And if grace is kind, this term, the Supreme Court is going to strike down Chevron. It might be coming to an end. I have my fingers crossed. I'm very, very excited. How long have I been an attorney? 16 years. Overturn Chevron. Chevron needs to die horribly. Also, while we're at it, can we do something about qualified immunity? Because qualified immunity drives me crazy. Because you need to find it, because in order to sue the cops, for example, because they screwed with you, in order to sue the cops, you need to find it's clearly established. So here's what happens. You sue the cops because they did something to you. Then the court says it's not clearly established, so you can't sue the cops. So they dismiss the case. But because they dismiss the case, it's not clearly established. So then move forward a couple years, and it happens again. And someone else sues the cops and says, hey, the cops screwed with me. And the court says, well, you can't sue the cops because it's not clearly established. But then they dismiss it, so it's not clearly established. And then a couple of years later, another person comes and says the same thing. It just keeps happening over and over and over. They never actually clearly establish the law. It's really annoying. I want to go back to the reasonable officer standard. It was great. The reasonable officer standard is the way we should go. How about the reasonably prudent officer was the great standard? You know, that would be fine. But this qualified immunity garbage has got to go. Why are we subjected to this guy? Because Destiny loves you, and Destiny wants you to get good quality legal advice from the channel Uncivil Law. That's right. YouTube.com/@uncivil-law. For all your quality legal advice, please go over there and subscribe today. And you get to have more quality legal advice from me, your host, Uncivil Law. Am I a libertarian? No, I consider myself more conservative. I'm consider myself a Republican, not libertarian. In fact, you could do it right now because there's nothing happening on stream. You know, you could open another tab right now as you're speaking, maybe. You could do that. How about you go over to another tab of YouTube and look up the channel Uncivil Law and hit that beautiful, beautiful subscribe button. That would be appreciated. Not happening? Oh, that's okay. Well, maybe another time. Am I still talking? Yes, at the moment, because I'm trying to fill time. I've been left alone, and I'm trying to fill time in Destiny's absence. I'm doing fine. Thank you for asking. I'm having a great day. I've been going to the gym a lot more recently. I've been having a lot of success at the gym. Recently, I did a leg press at 748-pound leg press for 3 sets of 10. So I was pretty excited about that. New PR. Kick ass. Please stop talking, but I'm the only one here. I've got to hold the court. Yeah. Please give us a case you didn't like, but the reasoning of the court changed my opinion. Let me think. A case I didn't like, but the reasoning changed my opinion. Oh, man, I don't know if I can think of anything off the top of my head. I'm sure it's happened. There was a case dealing with whether or not women should be subject to the draft. that I thought, where the Supreme Court pointed out that only it can change the law, that I thought was pretty persuasive. I guess that comes to mind. Oh, people want, someone on my own chat wants me to tell you the bee fish story. All right, you guys will like this. So one of the things I have on my shelf on my channel, I have a bee that is a fish. Here is the story. The state of California, people in California wanted to protect bees. They're concerned about colony collapse, okay? Now, the state of California has an Endangered Species Act of its own. They have their very own state-level Endangered Species Act. The state-level Endangered Species Act does not protect bees. However, the state law did protect fish. And fish were defined in the relevant law as being mollusks, some other things, other invertebrates, and blah, blah, blah. And someone sued, arguing that bees, being invertebrates, are therefore fish. And the Court of Appeals ruled that bees are legally fish. It was the Almond Alliance versus, I want to say, it was the Almond Alliance versus the Fish and Game Commission, if you want to go look it up in California law. Have fun. Bees are legally fish in California. So I have a friend, I call it Callie the bee fish. And
Yo, fam.
My name is Callie, and I'm a bee fish, and I love you very much. I go buzz, buzz, buzz in the ocean, buzz, 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 swimming around, buzz, buzz, buzz. I'm Callie the bee fish, Callie the bee fish. I like to point out that Callie is a freshwater fish that swims in the ocean. And if you're thinking to yourself, geez, that's a contradiction, I'd like to remind yourself that this is a bee that's also a fish. So your rules of logic do not apply in my universe. Can I explain why a civil judgment can be literally meaningless? Yeah, collection on civil judgments is hard, as anyone who does it tells you. Sometimes it's because they don't have money, and sometimes it's because respective state law provides them a lot of protection. Why didn't they just make a law to protect bees? That's an outstanding question. Why didn't they just go to the legislature and get a law that protect bees? That is a really good question. I don't know. Instead, they got the Almond Alliance with the help of the Xerxes Society, and I'm not making that up. That's their name. The Almond Alliance and the Xerxes Societies teamed up in a lawsuit against the Fish and Wildlife Commission to argue that bees are fish. This is the kind of high quality content you get on Uncivil Law.